Testing. Hi, this is Joe Taylor from Public Service. Harriet, can you hear me?
Not Harriet, but I can hear you.
Oh,
Good
okay.
morning. I'm just checking as well.
I can hear you as well.
Thank you so much.
Excellent.
Morning, everyone. Can you see and hear me?
Yep.
I can.
Thank you.
Okay, can you hear me now?
Okay, so then say yes there.
Yes.
Thank you, Harriet. That speaker is not loud enough. Test 1, 2, 3.
Yes, I can hear you.
Thank you.
Good morning. We're now on the record. It's 9 a.m. on Tuesday, May 27th, 2025. This is an evidentiary hearing in proceeding number 25A-0075E, Public Service Company of Colorado's application requesting its determination that it is in the public interest for the company to participate in SPP's regional day-ahead market called Markets Plus and associated cost recovery through the ECA. Eric Blank, the Commission Chair. Can my colleagues introduce themselves for the record, starting with Commissioner Gilman?
Morning, everyone. Commissioner Megan Gilman.
Good morning, Commissioner Tom Plant.
Thank you. Let's start with entries of appearance, beginning with public service.
Good morning. Stephen H. Denman of XL Energy Services on behalf of Public Service Company of Colorado.
Trial staff.
Good morning, Your Honor. Brian Krakis from the Attorney General's Office. Along with me is my co-counsel, Justin Larson.
Welcome. UCA.
Good morning. This is Patrick Woodersheim of the Attorney General's Office. I'm joined by co-counsel Tom Dixon.
Climax.
Good morning, Mr. Chairman and Commissioners. Richard Fanyo on behalf of Climax Molybdenum Company.
Interwest.
Thank you. Good morning. Chris Leger for the Interwest Energy Alliance.
Thank you, sir. Black Hills.
Good morning. Greg Sopkin representing Black Hills, Colorado Electric.
Colorado Energy Office.
Good morning. Jessica Lowry, First Assistant Attorney General representing the Colorado Energy Office. And I would like to also enter the appearance of my co-counsel, Valen Colros, Assistant Attorney General Fellow, also representing the Energy Office. Good morning.
Welcome. Tri-State.
Good morning. Dietrich Hefner of the law firm Womble Bond Dickinson on behalf of Tri-State Generation and Transmission Association.
Welcome. Colorado Energy Consumers.
Good morning, Mr. Chair, Commissioners. Michelle King of the law firm Holland and Hart. I'm here with my co-counsel, William, also known as Fripp Prelo, and we are here on behalf of the Colorado Energy Consumers.
Welcome. Western Resource Advocates.
Good morning. Parks Broso on behalf of Western Resource Advocates.
Welcome. Advanced Energy United.
Good morning, Chairman and Commissioners. Sarah Keene of the law firm Kaplan Kirsch and Rockwell on behalf of Advanced Energy United.
Welcome. Holy Cross Electric.
Good morning, Mr. Chairman. Good morning, Commissioners. Mark Detsky on behalf of the law firm of Dietza and Davis. Entering my appearance on behalf of Holy Cross Energy. I'd also like to enter the appearance of Daniel Rubin.
Welcome. And finally, Commission Counsel.
Morning. I'm Assistant Attorney General Wendy Rosati, and I'm joined by my colleague, Assistant Attorney General Mitchell DeCenzo.
Thank you. Did we miss anyone? Great. We're going to conduct this hearing using electronic exhibits. A spreadsheet marked as hearing exhibit 1400 lists the latest versions of the pre-filed testimony and attachment. With that, any objection to the admission of hearing exhibit 1400? Mr.
No
Denman?
objection. No objection, Your Honor.
Any objection from anyone else? Mr. Krakis?
I was just going to say no objection, Mr. Chairman. Thank you.
Thanks. Hearing none, exhibit 1400 is admitted. Any objections to admitting the documents included on hearing exhibit 1400? And I guess to the extent there's changes, we'll take them up with the end of, or revisions, we'll take them up with the witnesses when they come on. Without any objections to admitting the documents included on hearing exhibit 1400.
So, Your Honor, clarification, any of the corrections that were filed by the correction date are not on hearing exhibit 1400. Is that your understanding?
I don't know.
They are. If it was filed by last Thursday, they are on the exhibit spreadsheet.
I had someone check and I understood they were, but I just wanted to make sure the print's kind of small on my screen. Thank you.
Any objections?
No, Your Honor.
Hearing none, the pre-filed exhibits listed on hearing exhibit 1400 as filed in the commission's e-filing systems are admitted. Let's go through the witness list. It looks like everybody has crossed, so it doesn't look like we're going to be excusing any witnesses. Are there any modifications to the cross-examination matrix?
Yes, Mr. Chairman. Mark Detsky, behalf of Holy Cross. Holy Cross is going to waive its cross of Mr. Burman, but we may need to move some of that time over to Mr. Taylor. So net should be about the same, but we're going to waive cross of Mr. Burman.
Okay. Any other changes to the cross-examination matrix?
Mr. Chair, CEC was a little ambitious in our cross-examination estimates, and so we expect to reduce the 90 minutes that we had reserved to probably closer to 60 on total, if not less than that.
Greatly appreciated. Anyone else? Well, I just say we have 2.5 days available for the hearing with scheduled cross-examination, questions by the commissioners, redirect, and procedural matters. I'm concerned we're going to run out of time. So I just strongly encourage the attorneys to use their time efficiently, to listen to the other cross, and to ensure their issues have not already been addressed. And I just want to say we're going to be watching the time limits closely, and we may have to shorten our breaks or start earlier or go later. The commission has very little, zero flexibility to take on additional hearing dates at this point. So we got to get this into the 2.5 days. With that, are there any other preliminary matters we need to address before we start with the first witness?
We have none.
Mr. Fangio.
Mr. Chair, was a little slow with my audio button, but I expect my cross of the 3 witnesses to be less than I've reserved on the matrix, possibly waiving 1 or more, but we'll see how it goes and how the prior cross goes to affect that.
Appreciate that. Any other preliminary matters before we begin?
No.
With that, are you out there, Mr. Taylor?
I am. Good morning.
Morning. Can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, you'll let us know.
I will.
Back to you, Mr. Denman.
Thank you, Mr. Chairman. Mr. Taylor, please state your name and business address for the record.
My name is Joseph C. Taylor. I work for Public Service Company of Colorado. My address is 3500 Blake Street in Denver.
And what is your title, Mr. Taylor?
I'm Senior Director, Western Markets for Public Service.
In the course of this proceeding, did you cause to be filed hearing exhibit 101, your direct testimony and attachments, and hearing exhibit 103, your rebuttal testimony and attachments?
Yes.
And those exhibits were admitted this morning as part of hearing exhibit 1400. I note for the record that there was a slight revision to hearing exhibit 101 on page 68. And I understand from Ms. Federico that that was included on hearing exhibit 1400, and it's now in the record, Your Honor. Mr. Taylor, if I were to ask you today the same questions under oath that appear in hearing exhibit 101 and hearing exhibit 103, would your answers be the same?
Yes, they would.
And you adopt the testimony in hearing exhibits 101 and 103 as your sworn testimony today?
Yes, I do.
Thank you. Your Honor, that completes my direct examination, and Mr. Taylor is available for cross-examination.
Thank you. Ms. Keen, AEU, I have 80 minutes and it's 9:10, 9:11.
Good morning. Good morning, Mr. Taylor. Just to confirm, it's Ms. Federico that's driving the box?
Yes, it's me.
Great, thank you so much. Mr. Taylor, I want to start with something you said in your rebuttal testimony. You noted that the start date of Markets Plus has been moved back from April 2027 to October 2027. Is that correct?
Yes.
What is the reason for the start date being moved back?
I'm not 100% sure of the reason, except that the delay in the FERC approvals, both originally and in the approval of the phase 2 financing agreement, both led to the need to extend the start date to October.
So saying you're not 100% sure, was public service involved in the discussions or the decision making regarding pushing that start date back?
Only peripherally. Public service is not a phase 2 funding party at this point. The phase 2 funding parties have been gathering, along with SBP to set up the schedule, and we were informed in advance of the April MPEC meeting that the date was being pushed out to later in 2027.
Thank you. Do you think there's a possibility that that date could get pushed back further?
I don't believe so. The amount of time to develop the market certainly fits within that, within the time frame between now and October 2027.
Great, thank you. Switching topics, you had testified in your direct testimony that joining the SPP, Western Energy and Balance Service Market, or WISE, was an incremental step in public services transition to participating in an organized wholesale market as required by Senate Bill 21072. Does that sound right?
Yes.
And you also have stated that joining Markets Plus represents a next step in the company's participation in regional markets. Is that also right?
Yes, it is.
And so when you say a next step, is it your opinion that joining Markets Plus would itself satisfy the company's obligations to join an organized wholesale market as required by Senate Bill 72?
Objection, Your Honor. That calls for a legal conclusion. It
Can you
requires a
repeat
wit.
the
It requires a wit. I'm sorry.
Can you
Go
repeat
ahead.
the question?
I was wondering if, in Mr. Taylor's opinion, whether joining Markets Plus would be a next step in meeting SB 72 requirements, would itself comply with SB 72's requirement to join an organized wholesale market by 2030?
I'd overrule the objection and allow Mr. Taylor to answer with the understanding that he's not a lawyer and the company may have the ability to clarify on statement of position. But if you can answer this question, Mr. Taylor, that'd be great.
Thank you, Your Honor.
So yes, Markets Plus is the next step in our evolution. We followed. Sorry, there was a echo there. We followed the OWM rules in this application and recognized that Senate Bill 72 requires participation in a statutory OWM by 2030, unless there's no available OWM, or unless the company requests an extension or a delay in that 2030 date.
Thank you. Understanding you're not an attorney, is it your understanding that Markets Plus meets the definition of OWM under the statute?
No, Markets Plus is a day-ahead market. It doesn't meet the statutory, all of the rules of a statutory OWM that's defined in the rules.
Thank you. And you referenced that under SB 72, the Commission may waive or delay a requirement to join an OWM, is that correct?
Yes, that sounds right.
Are you aware that one of the conditions for granting a delay or waiver by the Commission is if the Commission determines that the utility has made all reasonable efforts to comply with the requirement to join an organized wholesale market, but there's no viable and available market to join?
That matches my recollection, yes.
And I'm also happy to pull up a copy of the statute at any point if that would be useful. Do you
Your
think
Honor,
that joining market?
can I interject? Council appears to be intending to ask Mr. Taylor questions that are so close to the line of asking for a legal interpretation of the statute and rules. I don't want to continue to object. However, Your Honor made it clear that Mr. Taylor is not providing legal interpretations. He's here testifying as an expert witness on markets and on this application. So with that understanding, I don't need to make a continuing objection.
So understood. Mr. Taylor is not an attorney, but as the lead policy witness, I think this line of questioning is legitimate, and we'll collectively understand that the company has the ability to clarify legal positions in its statement of position. So with that clearly on the record, Ms. King, keep going.
Thank you, Chair. Do you think that joining Markets Plus would constitute reasonable efforts to comply with the requirement to join an organized wholesale market by 2030?
The company believes Markets Plus is the right way to go now. It's an energy and flexibility reserves market that is run by a competent market operator. We believe it has benefits for our customers, and importantly, doesn't require the company to give up control of its transmission, of its resource and generation planning.
I'm going to cut you off there if we can, just because it's a yes or no question, and we'll get to all of the reasons a little bit later.
Well, Your Honor, can you instruct counsel to please let the witness finish his answer?
I had asked if he thought it was reasonable efforts within the meaning of Senate Bill 2172 to comply with an organized wholesale market. I was not asking for the reasons why you were seeking.
Well, objection overruled. I'll allow counsel to control the cross if Mr. Taylor thinks more clarification is necessary. I'll allow it, but this objection is overruled. Keep going, Ms. King.
You have stated that the company is not joining SPP's RTO West. Is that correct?
That's correct. We're not joining RTO West at this time.
And based on your current knowledge, does Public Service intend to join any organized wholesale market by 2030?
Well, like I said in my previous answer, the application we filed is to join Markets Plus. In the future, we'll evaluate moving forward into statutory OWM based on the facts as they work out over the next few years.
Let's assume for the moment that Public Service does join a different organized wholesale market by 2030, in addition to Markets Plus. Do you have a sense of roughly how long before that 2030 deadline Public Service would need to start making plans to join such a market?
Already, if I think about it, being in Markets Plus and having the same market operator, the same network model, transitioning to an organized wholesale market managed by SPP would be a probably 12 to 18 month endeavor once we've made that decision. But of course, the loss of control of our transmission system, the issues that RTOs are having nationwide and studying and interconnecting new generation, new load, transmission expansion. Those are all considerations that we will have to take into account before we ever make the jump to, an RTO membership.
Thank you. Under the statute, you're aware, and the Commission's rules, are you aware that applying to join an organized wholesale market would need to be made at least 18 months in advance of joining that market?
I don't remember the exact date out of the rules.
No problem. Well, assuming that it is correct that you have to apply to the Commission at least 18 months in advance, and you stated earlier Markets Plus is not going to start until October 27, that seems to me that you would need to apply to join an organized wholesale market no later than mid-2028 in order to meet that 18-month deadline. Does that sound correct?
That would be 18 months in advance of 2030.
And so if you join Markets Plus in October 27, we have at most, say, 9 months or so of experience within Markets Plus before you would need to come back to the Commission to apply for joining an organized wholesale market. Is that right?
If we were applying to join the statutory OWM, yes.
Thank you. Does it seem possible under that scenario that you are joining an additional market in addition to Markets Plus, that a whole new set of costs would be incurred, including costs for administrative fees, IT costs, upgrades, potentially transmission costs, et cetera, associated with that new market?
There would be new costs, of course.
Yeah. I'd like to turn now to some issues regarding resource adequacy. You testified that entities joining Markets Plus would be required to join the Western Resource Adequacy Program, or WRAP. Is that correct?
Yes, that is a requirement.
And so you can't join Markets Plus without joining WRAP, right?
Correct.
And so asking the Commission to approve your entry into Markets Plus is also asking the Commission to approve your entry into WRAP effectively. Is that right?
Yes, that's right.
If the application is approved, does Public Service intend to start participating in WRAP at the go-live date for Markets Plus in October 27 or at some prior date?
We'd start, we're not a participant in WRAP today, so as I understand, they have a onboarding program that takes some time, and obviously our onboarding would take place and we would formally be a member by the time Markets Plus starts.
To what extent has the company participated in the ongoing development of the WRAP program?
I'm sorry, can you ask that again, please?
Sure. To what extent has the company participated in the development of the RAP?
We were engaged early on in the RAP program for, if I remember right, about a year. And then we stopped that engagement in probably 2022, maybe early 2023.
Thank you. So is it fair to say that there is not a current representative of public service on RAP committees, such as the Resource Adequacy Participation Committee or the Program Review Committee?
That's correct.
And do you know if anyone from a public service or Excel has participated in any of these RAP committee meetings recently?
Not currently. We've participated and called into several of those over the past few years, but we're not a member of any of them.
Thank you. And is it your belief that the Western Power Pool has been developing the RAP specifically with the expectation that public service will participate in the program?
I've never heard that expectation, no.
In your testimony, Mr. Taylor, you explained that the RAP uses calculation methods such as the effective load carrying capacity, or ELCC, the loss of load expectation, or LOLE, and the planning reserve margin, PRM, also derived capacity accreditation. Is that correct?
Correct. The ELCC and they have other terms that define the capability, particularly of any type of unit. That one added together ultimately your firm load, your firm commitment, and then that margin is the margin that's determined is called the planning reserve margin, or the PRM.
Thank you. And are you aware that Western Power Pool generally has been conducting studies and analyses as they develop the program regarding these metrics, ELCC, loss of load expectation, PRM, et cetera?
Yes, I review those in a number of stakeholder meetings and materials that are posted on their website.
Great, thank you. And in any of these studies or materials that you referenced, has public services, loads, or resources been included in the assumptions underlying those studies?
I don't think on a specific basis. We're in one of the RAP regions where the ELCCs are determined, but not, I don't recall beyond the first set of data that public service provided a few years ago. So any specific public service data would probably be a few years old.
Okay, thank you. You mentioned the RAP regions. Those are generally considered the Southwest and Northwest regions of RAP, is that correct?
It's been a while since I looked, but there's Southwest and Northwest, and then the Rockies are in, I can't remember if they're in their own region or combined in with the Southwest region.
Okay, so we're not sure on that. Is it correct that when the RAP models its loss of load expectation, it also includes 9 load resources zones? Are you familiar with that?
I am not.
Okay, so you're not sure which load resource zone public service would be placed in?
No.
Okay. Do you know if RAP were to update its analyses, its ELCC and planning reserve margin analyses and its transmission studies to account for public services participation? Do you know how long, any guess how long those studies may take?
No, I think that's part of the onboarding process that we have.
Okay, thank you. If this application is not approved or public service for whatever reason otherwise doesn't end up joining Markets Plus, would public service still intend to join RAP?
I'm not prepared to answer that question. That's not a decision that has been asked internally yet.
Okay. Has public service analyzed the costs and benefits to its customers of joining RAP?
No, just with comparison of the data we've seen from the posted RAP studies and the resulting PRMs and how those compare to those that we are proposing in our various resource plans.
Okay, so just make sure I heard that right. So you have analyzed you reviewed the studies that they have conducted, but you haven't independently analyze specific costs or benefits to public services customers. Is that right?
We've compared them to what we have had as PRMs in our resource planning process.
Okay. Can you describe at a high level how PRMs that you currently calculate as part of your ERP process compares to how it's calculated for RAP?
I had a question and answer in my rebuttal testimony about that. So if you'll give me a moment, I will look for that. Sorry, I'm having trouble remembering where in my rebuttal testimony that is.
No problem. If helpful, I can also pick up with a different line of questions and similar, but a little different, and come back to this if that's
okay. That works.
Well, perhaps it would help, Your Honor, if counsel could point the witness to somewhere in testimony that her questions relate to.
Ms. King.
That is fine by me. No objection. Thank you, Mr. Denman. Let me go back to, I'll circle back to what Mr. Taylor was referring to in a moment, but to back up a minute, back in your direct testimony, you stated that the Colorado Electric Resource Plan process will continue to operate independent of the RAP and Markets Plus, but that the calculation methods used may adapt or evolve to align with the RAP. Is that right? I'm happy to point you to a page of direct testimony if that would be helpful.
That sounds familiar. If you could point me to the page, that would be.
Sure. That's Hearing Exhibit 101, page 44. Thank you, Ms. Federico. Starting on line 12. Just to repeat my question, you had stated that the ERP process will continue to operate independent of RAP and Markets Plus, but that the calculation methods may adapt or evolve to align with the RAP. Does that sound about right?
Yes, that's correct.
Can you describe how the company intends to integrate its resource adequacy through the ERP process with its participation in the RAP?
The RAP program is it's a short term, it's a view of, the ultimate PRM for the company for the following summer or winter season. The ERP processes, of course, are, more than several years, where the company plans to, meet its load plus PRM years into the future. So RAP is going to be useful to acquire resources when the company is short in the shorter term, and provide the ability to even sell extra capacity to the extent we're long to other RAP participants.
Thank you. Do you expect that the company will be seeking approval in ERP proceedings in the future for those sorts of actions that the company needs to take in order to meet the RAP requirements?
I'm not familiar with the requirements on purchases and sales of that type.
No problem. Thank you. On the same page of this testimony, you note that the capacity accreditation calculation methods that public service uses are similar to, but not exactly the same as the methods used by RAP. Direct your attention to lines 10 through 12 for that. Does that sound right?
I see that, yes.
And can you explain how the two capacity accreditation methods are similar and how they are different?
I'm certainly not the expert on these capacity accreditations. I know there are different methodologies that are used. You have ICAP and UCAP and another methodology, but I understand that we may not be using the same methodology that RAP is today, which results in numbers that are, just results of different results based on how the resources are studied through the accreditation process.
Thank you. You're not, familiar with the specific details here. Are either of the other two witnesses that the company is presenting today, should these questions be deferred to them, or do you think that none of the witnesses here are likely to be able to answer that?
The latter. I think neither of the other two witnesses are experts on our resource accreditation and practices.
Okay. Generally speaking, do you know if the planning reserve margin that public service currently uses is likely to be lower or higher than what is required for RAP, or what is used by RAP?
The numbers I've seen, the RAP planning reserve margins that I've seen recently are lower than the planning reserve margins that we've presented.
Okay, thank you. If we want to jump to page 33 of this hearing exhibit 101, please. Here you provide, and under paragraph 2, you provide an overview of the RAP's compliance requirements, including an explanation of the forward showing requirement and the operation program requirement. Is that right?
Yes.
And has public service analyzed its ability to comply with these two aspects of the RAP's compliance requirements?
No, other than the comparison I just made between the results of recent RAP studies and our own results.
Okay, thank you. So is it, sorry to cut you off. Thank you.
I know I didn't get that answer. I didn't get the last part. Sorry. Mr. Taylor's answer. The answer.
I think the last part was comparing the RAP results with what we have in our resource plans.
So is it fair to say then that public service has not yet started planning for how you would specifically comply with the forward showing requirements for the RAP?
That's correct. We provided data a few years ago, but we haven't provided updated data.
Okay. With that in mind, I'm just going to figure out where I'm going to jump to next. One moment, please. Okay, you explain here in your testimony, starting on line 11, that as part of the forward showing requirement of the RAP, participants must show that they have at least 75% of the transmission capacity needed to deliver sufficient capacity to meet the PRM load. Is that right?
Yes, that's what I said.
And has the company analyzed the impact of participating in RAP with regard to what new transmission might be needed in order to make this forward showing?
What new transmission?
Yeah, like if there will be new transmission that's needed, new transmission capacity needed for the showing.
No, at this point, a perfect example of having transmission available that could meet the company's PRM obligations to the extent we were short would be the transmission import capability that the company owns between the Four Corners area and our system.
Thank you. In addition to that, is it possible that the company might need to build new transmission or expand existing transmission facilities in order to meet RAP requirements that it otherwise wouldn't be required to build?
Building new transmission is going to have many components, right? It's going to have many, potential benefits to, including exchanging more energy with other Marcus Plus parties, and would then, of course, allow for additional changes of capacity even in the RAP program. So new transmission, has a number of benefits, and meeting a future obligation or being able to supply for somebody else's future obligation would certainly be two of those options.
Thank you. Just to clarify, do you think it is understanding that transmission has multiple benefits and serves multiple uses? Do you think it is possible that the commission may need to expand or build new transmission in order to meet RAP requirements that wouldn't have to meet, or we're not participating in the RAP? Is that a possible future?
Well, I think the resource, to meet a planning reserve margin, you have transmission solutions, but you also have, of course, generation resource solutions. So those are, the two options to meet load. So transmission is certainly not, the only one.
Going back to the RAP compliance requirements with regard to the operations program, you've explained that participation will provide the opportunity to purchase and sell capacity with other RAP participants in order to meet those requirements. Is that right?
That's close. The operations program is an energy.
Oh, sorry.
Not
energy. I'm sorry. I said capacity. I didn't mean energy. And in the event of a scarcity condition forecasted within the operations period, RAP participants might be asked to hold back generation during critical periods for potential use by other program participants who lack sufficient resources to meet their own load in real time. Is that comport with your understanding?
Yes, it does.
Has public service analyzed the extent to which this holdback requirement might create additional operational constraints for public service?
No, we haven't, but the holdback requirement applies to those who have sufficient PRM in the forward program is my understanding. So the idea is that those who have available capacity at the worst times can hold that back for those who don't.
Thank you. Are you aware of the April 8th executive order issued by President Trump, which is called Strengthening the Reliability and Security of the United States Electric Grid?
Not besides the title of it that you just described.
Okay, so is it fair to say that Public Service, to your knowledge, hasn't analyzed whether that executive order might apply to the RAP?
I certainly have not.
Okay, thank you. And are you aware that the U.S. Department of Energy began issuing orders as of May 23rd last week to secure grid reliability ahead of summer months? Familiar with any of that?
I'm not.
Okay, and so also fair to say that you haven't, to your knowledge, Public Service hasn't analyzed the potential impact of that order on the RAP.
I certainly have not.
Thank you. Switching topics, I'm going to hit some things relating to scenes. So I'd like to turn, just remind ourselves on the requirements of Rule 3735A2, which you cite in your testimony. As applied to this proceeding under this rule, it's Public Service's obligation to demonstrate that Markets Plus has a plan in place, has a plan to put in place policies and operational practices to optimize the efficient dispatch, exchange of energy, and unit commitment between markets, if there is more than one regional market construct operating or proposed to operate in Colorado. Does that sound right to you? Subject to check on the wording.
Right, yeah, subject to check. That sounds close anyway.
Thank you. Do you agree that there is more than one regional market construct proposed to operate in Colorado?
I am, yes.
And is it accurate to say that for the moment, the market constructs proposed to operate in Colorado include at least Markets Plus, as well as the SPP RTO expansion, which Tri-State Generation and Transmission and other Colorado utilities intend to join?
That's true. And Tri-State also has load and generation in the Public Service BA that would most likely go into Markets Plus as well.
Thank you. And so would you agree that Public Service has the burden of proving that Markets Plus has a plan in place, sorry, I keep saying that Markets Plus has a plan to put in place policies and operational practices to optimize the efficient dispatch, exchange of energy, and unit commitment between at least Markets Plus and SPP RTO West?
I object to these additional questions that are now across the line of legal conclusions.
I'm happy to.
If council can stop asking about burdens of proof and asking the witness to draw legal conclusions, we all know as lawyers who's got the burden of proof in this case. You don't need to ask a witness that, Your Honor. And
sorry, the purpose of my question was not to establish a burden of proof. It was to confirm which specific markets the burden of proof applies to with regard to application.
It's the same problem, Your Honor. Why can't counsel just ask witness questions that are within his area of expertise? We're going to address all these legal questions on our statement of position, and it's just improper to ask witnesses questions that ask for legal conclusions. We all know that.
The objection's overruled. I think Ms. Keene hadn't even finished her question. So Ms. Keene asks the question again, and if Mr. Denman wants to renew his objection, we'll take it up then. So can you repeat or finish asking your question?
Thank you, Chair. Is it accurate, because of the market constructs that we already discussed, that in this application, public service needed to demonstrate that there is a plan in place, or that is a plan to put in place policies and operational practices to optimize the efficient dispatch, exchange of energy, and unit commitments, specifically between Markets Plus and SPP RTO expansion.
Yes, that there be a plan to put a plan in place. We've demonstrated that we've begun those efforts already with, especially with the real-time dispatchable transactions that I talked about in my direct and rebuttal testimonies.
Thank you. Are you aware, Mr. Taylor, of any documents that Markets Plus has approved that specifically address themes, issues, and optimization as between Markets Plus and SPP RTO West?
The SEAMS document that was approved last month by the MPEC is the starting point for SPP's efforts to address SEAMS with any adjacent system, whether they be in a market or in the SPP RTO or the SPP RTO expansion.
Okay. Thank you, Mr. Taylor. I'd like to pull up a copy of that document. I have it, sorry, orders, but since you brought this up, 1 minute. Ms. Federico, I have this pre-marked as hearing exhibit 902. If we could pull this up, please.
Yes, and Ms. King, just so you know, I sent you an email about your exhibits. They, in your box, they have some issues. I'll still pull it up, but they have some issues that you'll need to address before I can move them over into
Sure,
our
I'm happy to
folder.
address that as soon as we get that to a break, and my apologies for that. Great, thank you. Do you recognize this document, Mr. Taylor?
Yes, I do.
And this is the SEAM strategy and framework roadmap. You had previously included an earlier version, or have referenced an earlier version of this roadmap document in your direct testimony, is that correct?
Yes, and then I included this version as attachment JCT8 to my rebuttal.
Oh, my apologies for that. We can just use that version. If we could slide down to page 5.
Did you want me to pull it up from his, or?
It's the same document, so whatever you prefer, and I'm happy to clean up the record if you.
Well, in fact, perhaps I can help. The document, which is Mr. Taylor's hearing exhibit 103 attachment JCT-8, is already in the record, so we don't need to try to fumble with the additional hearing exhibit 102 marked.
Yeah, sorry, that's what I was trying to say, and my apologies for that. It's been a kind of a rush process the last couple of weeks.
Yes, that helps. That helps also because this one is a PDF and has page numbers. So thank you.
Thank you very much. So here on page 5 in the executive summary, can you please read the third paragraph, which begins with this paper?
This paper is not intended to provide solutions and recommendations as to how the documented SEAMS elements should be addressed, but rather simply document these areas with proper context to understand what the SEAMS elements are and that these items should be addressed as Markets Plus continues to evolve to go live and beyond.
Thank you. So this white paper, even when it is finalized, will not itself specify the policies and operational practices that are needed to address the SEAMS issues. Is that accurate?
It identifies them. It's not a solution.
And is any document that would identify the solutions has that been commenced yet? To your knowledge?
Not to my knowledge. I will say one of SPP's roles in phase 2, and it's documented in the phase 2 funding agreement, and we can go look at that if you like, is to implement optimization strategies like SEAMS as well.
And what is the current status of this roadmap document? Could just summarize that, please.
Of which document, Ms. King?
Oh, sorry, the SEAMS strategy and framework roadmap that we have on the page. You had mentioned that it had been approved in an April committee meeting. Is there further approvals that will be required?
I believe the Markets Plus Executive Committee, or the MPEC approval, was the approval required. SPP staff got future action items to document and start to prepare timelines and actionable goals, if you will. That's all referenced in the meeting minutes of that MPEC meeting where this document was approved.
Okay, great, thank you. If we could jump to page 13 of this document, please. Could you scroll down, please, Ms. Federici? I must have different numbering. I'll skip that for now. Thank you. Okay. Jumping back to, we can take this document down now. Thank you. Mr. Taylor, back in your direct testimony, you discussed some things that you characterized as tools for SEAMS coordination between markets that have been developed so far, and you've referenced some of those already. Is that correct?
You want to point me?
Sure. On Hearing Exhibit 101, page 35.
Thank you.
On lines 8 and 9, you discuss things that you characterize as tools for SEAM coordination between markets. Is that right?
Yes.
And one of the tools you discuss is the real-time dispatchable transactions, or RTD, correct?
RTDT, yes.
And you explain that RTDT is expected to be implemented by SPP by April 1st, 2026. Is that right?
Yes.
And so public service intends to use this tool before Markets Plus begins to operate, correct?
That's true. Starting in April 2026, the Weiss market that we're in today will go away. So public service won't be in the market for, almost a year and a half. So we plan to use this tool as to provide some of the benefits that we've gotten in our Weiss market directly with the RTO expansion.
And you would plan to continue using this tool even if you don't enter Markets Plus, is that right?
Yeah, real-time dispatchable transactions are available not just to public service, but to any transmission service provider that is adjacent to the RTO, or it even applies to those in the Eastern interconnection that aren't direct SPP RTO members. So it doesn't just apply to public service. It will also, it also applies to, for example, Pacific Corp, who is adjacent to SPP RTO expansion. So developing this tool for real time is will certainly be a good product for PSCO to use, but it's available market-wide, both east and west.
Thank you. And so based on that, it's fair to say that RTDT is not a tool that's specifically designed to address markets plus SEAMS issues, right?
RTDT is a tool to address a SEAM. The goal of that tool is to improve the efficiency between the RTO markets and between those in a different day-ahead market, a real-time market, or a no market at all.
And you also discussed in your testimony tool the area control diversity interchange, or ADI, is that right?
Yes, ACE diversity interchange, yeah.
And you're planning to use ADI whether or not you join Markets Plus?
ADI is, we have ADI today in our Weiss market. We plan to continue and have ADI in place with SPP RTO West when they go in to place. It provides flexibility and reliability benefits of sharing the difference between scheduled and actual loads and generation across BAs. Also plan, I think other Markets Plus parties either have ADI in place between themselves, but are interested in expanding that program with SPP when they begin the RTO expansion as well.
Thank you. We could jump to page 38 of the direct testimony, please. Mr. Taylor, on the top lines here, you identify as a midterm strategy to address these issues. You need to develop an actionable transmission plan to connect public services system with other Markets Plus utilities. Is that right?
That's correct.
And if this application is approved, when do you think Public Service would develop that actionable plan?
The planning would start soon after we have the approval to go into Markets Plus. And I think it would really be the transmission folks, the planners between the company and the other Markets Plus parties to develop the scope and timing of preparing that actionable transmission plan.
So just to make sure I heard what you say, we haven't begun the work on that actionable plan yet, and you would begin after the application were approved. Is that correct?
That's correct. We're not in Markets Plus yet, and so the developing the plan with other Markets Plus utilities first requires them to be Markets Plus parties or Markets Plus participants.
And what are the geographically closest utilities to Public Services system that have indicated an intent to participate in Markets Plus Phase 2?
I would say the closest are in the Four Corners area. The Arizona utilities, I think all three of the major Arizona utilities have transmission up to the Four Corners area.
So understanding that there's, the plan is not yet been developed, but do you have a rough sense of what projects or what types of projects might be needed to connect Public Service system to those utilities?
I do not. I'm not a transmission planner.
Do you know if anyone at Public Service has kind of roughed out those potential transmission developments yet or not?
No, I'm not aware.
Okay, and so you're not aware of what the potential cost, even at a very high level, of such new transmission might be?
No, I'm not.
Okay. Do you have a sense of the timing of when that actionable plan might be completed such that the commission would know what the cost of the additional plan transmission would be?
I think a couple of questions ago, tried to answer that exact question.
But you explained when it would begin. Do you know about how long it would take?
No, at this point, without public service being a Markets Plus participant, I can't say when that plan would start and when that plan would be completed, if you will.
Thank you. You referenced a little while ago that increasing regional transmission capacity brings multiple benefits. Is that correct? Or
Yes,
can?
it is.
Do you agree that those benefits include things such as increasing cost-effective imports and exports, which can reduce renewable curtailment?
Yes.
And do you agree that the benefits of increasing regional transmission can also include reliability benefits, such as from increased resilience to system problems, like N-1 conditions, as well as increased trading ability during extreme weather conditions?
Yes, I agree with that.
In addition to all these benefits, do you agree that developing regional transmission can be quite expensive?
Transmission can be expensive, yes.
All right. Hopefully that's not a controversial point. Do you agree that the company and the commission, because of these costs, need to carefully consider the costs against the full range of anticipated benefits from transmission before investing in a new transmission project?
Yes, I agree with that.
Assuming this application is approved, is it the company's position that increasing transmission connectivity with other Markets Plus utilities should be the primary factor driving the company's regional transmission planning efforts?
So is the question, would you ask me the question again, please?
Sure. If you're approved to join Markets Plus, when you think about the company's regional transmission planning efforts, is adding connectivity to other Markets Plus utilities a primary driver for what new regional transmission you consider?
I think it would be a driver. We'll always have regional, especially moving forward, we'll have regional transmission planning associated, even nearby, right, with our RTO West transmission owners, and SPP is the transmission provider in the RTO West.
You said it's a driver. What are the other kind of key drivers when you think about what regional transmission to build?
That was really the plan for new transmission between ourselves and Markets Plus parties, as well as future transmission between public service and the RTOS parties.
Would it be fair to characterize that when the company is developing new regional transmission, a key objective should be maximizing net benefits to customers?
Right, transmission investment has to be offset with benefits for sure.
Thank you. And would you agree that transmission development needs to be driven by the needs of the system and therefore designed in a way to maximize net benefits to ratepayers?
Right, transmission has to solve identified needs for sure.
Is it possible that the company would consider a new regional transmission project that would provide substantial net benefits, even if it doesn't increase connectivity to other Markets Plus customers? Sorry, other Markets Plus utilities?
I'm sorry, can you ask that again? That sometimes maybe you're speaking too quickly that I can't fully understand.
Sorry about that.
Yeah, you are kind of dropping a little bit, Sarah.
Sorry, let me get my microphone a little bit closer. Hopefully that'll be better, and I'll try to slow down.
Thank you.
Is it possible that the company would consider a new regional transmission project that would provide net benefits to its customers, even if it's not increasing connectivity to other Markets Plus utilities?
Yes, we would.
And conversely, is it possible that a proposed new regional transmission line would increase connectivity to Markets Plus customers? Sorry, I keep saying that. Would increase connectivity to Markets Plus utilities, but not provide substantial net benefits to public services customers?
Of course, that's why it's a component of a plan, is to determine whether it makes sense to, move forward with any specific transmission line or upgrade.
Okay. If the company expands regional transmission connectivity with other non-Markets Plus utilities, would you expect that seams friction between Markets Plus and these other utilities would increase or decrease?
I think the seam would be one of the barriers or one of the additional costs between public service, for example, as a Markets Plus party, and Pacific Corp, for example, as an EDAM party. Even though you connect those two systems, you can't exchange energy, at least today, without the friction of a transmission service reservation.
And in your direct testimony here on the page we have up, you identify as a long-term solution to seams issues building more transmission between Markets Plus and non-Markets Plus utilities, correct?
Yes, building transmission between Markets Plus and other utilities, yes.
But you just testified that doing so can increase some costs associated because of the seams issues. So can you explain why you believe that building more transmission connecting non-Markets Plus utilities would address seams issues?
I don't believe I characterized it that way, but building between non-Markets Plus utilities would add a transmission service charge. And so if the transmission upgrade can survive that charge and still provide benefits, then it could be, move forward.
And how would doing so address a seams issue?
Without a seam between the two markets, that issue would provide a project that's still cost beneficial, even though you have to buy transmission back and forth between the parties.
Thank you. I guess maybe let me just ask then, I'll rephrase. You say here that one of your long-term objectives is to build more transmission between Markets Plus and non-Markets Plus utilities, and that doing so is part of your strategy to address seams issues. How does building such transmission address the seams issues?
The building transmission and solving seams, I think, are two different issues. I think the markets operating in the West should have a common goal to reduce seams between those markets so that they can trade energy most efficiently. But today, that optimization obviously hasn't been completed yet, because neither of these two markets are even in service yet.
Okay, thank you. Go ahead and switch topics again. If we could turn to page 18, please.
And Ms. Keene, just so you know, about 15 minutes left, okay?
Yep, thank you, Chair. Starting on line 14, Mr. Taylor, you state that Markets Plus provides more benefits overall and in relation to cost relative to the other markets studied, including EDAM. Did I get that right?
Yes.
When you say studied here, Does that include any process that specifically examines the full range of economic costs and benefits of public service joining EDAM versus joining Markets Plus?
The full range?
I'll rephrase. Do you believe when you say studied here that that included any process that examined multiple benefits and costs associated with EDAM and Markets Plus?
No, I'm referring to the production cost benefit, production cost studies that were performed for us as part of the Western Markets Exploratory Group.
Okay. And as part of that study, I'll refer to that as the E3 study for ease of reference, if that works for you. As you mentioned, that E3 study was just a comparison of production costs for different markets, correct?
That's correct.
Okay, and so the E3 study didn't attempt to evaluate categories of costs or benefits other than production costs, is that right?
No, the E3 study was production cost benefits of utilities in different market footprints.
Okay,
The
and
two
so that
markets
E3
being the two markets being Markets Plus and the EDAM market.
Okay, thank you. And so the E3 study didn't include estimates from potential capacity savings that would be achieved from peak load or resource diversity, and it didn't include investment savings from market-enabled resource procurement over a wider geography, and it didn't include consideration of coordinated regional transmission planning or investment. Is that accurate?
That is correct. The WEMEG, the Western MEG, or I'll refer to them as WEMEG just because that's how I grew up with it, decided ultimately that the production cost differences that were ultimately performed by E3 were enough, or were all the parties were willing to agree to and pay for at this time. The other benefits that you described, capacity and whatnot, were discussed, but ultimately the study was just production costs.
Okay. And so there's nothing in the record in this proceeding that evaluates those other categories of benefits or costs of EDAM. Is that correct?
I wouldn't say completely, Ms. Keene. The company included the E3 production cost study as well as all of the other WEMEG study results or white papers in this proceeding. And in those are various other opportunities that are discussed between the parties on some of the topics that you talk about, like VA consolidation and capacity savings and things like that.
Okay. But public service hasn't independently analyzed the benefits or costs of joining EDAM as compared to Markets Plus, correct?
We did. The EDAM footprint was studied as part of the E3 study. So that included results of public service and virtually the whole West being in EDAM.
Okay. But public service has not undertaken any study that looks at these other types of benefits and costs previously referenced of joining EDAM. Is that correct? Except to the extent that they are embedded in prior WEMEG assumptions.
Right, just the production costs that were included in the EDAM footprint, which is production costs.
Is it your opinion that if public service were to conduct a standalone study comparing the overall economic costs and benefits of joining Markets Plus as compared to the overall costs and benefits of public service joining EDAM, that the study would show more benefits overall in relation to costs for Markets Plus?
Yes, I believe Markets Plus is the most cost-effective day-ahead market, especially on a long-term basis, because, and I don't have specific quotes from the California ISO as to the cost to be in EDAM, but my understanding is that the annual administrative costs of being in EDAM are, 2 to 3 times higher than the administrative costs of Markets Plus. And so while Markets Plus may require more upfront, collateral to join, on an ongoing basis, it's going to be substantially less expensive on an annual basis than EDAM.
You testified this morning that all of your questions and answers in your direct and rebuttal testimony would be the same if you had given them again today. Is that correct?
Yes.
And so it's still your testimony then that the best available analysis regarding the relative costs and benefits of the company joining Markets Plus as compared to EDAM is limited to the WEMEG study. Is that correct?
Yes.
Are you aware that Aurora Energy Research recently completed a study that specifically compares the costs and benefits of public service joining Markets Plus and EDAM, the results of which were filed as an attachment to public comments in this proceeding?
I'm aware of the existence of the study based on an email I received from EDF, but I haven't looked at that study.
If you were to look at the results of that study, would you agree that a study that specifically compares public services entry into EDAM and to Markets Plus should be considered as part of the best available evidence relating to this question?
Objection, Your Honor. He just said he hadn't looked at the study. It's not fair to ask him a question like that.
To be clear, I'm not asking him to opine on the results of the study. His testimony is that the best available evidence for the commission to consider regarding EDAM is this WEMEG study from a few years ago. I believe it is appropriate to consider as impeachment evidence the existence of this additional study, questioning his conclusion about the best available.
Well, Your Honor, somebody who filed some so-called study as a public comment the weekend before this case went to trial is classic ambush. I object to any further inquiry about this so-called Aurora Energy Research study.
I'd overrule the objection and allow Mr. Taylor to answer the question any way he sees fit. Mr. Taylor?
Would it be helpful to repeat the question at this point?
That would be helpful.
Thank you. Knowing that there is a study out there specific to public services entry of Markets Plus and EDAM that studies the costs and benefits of each, would you consider that to be part of the best available information in addition to the WEMEG study that we previously noted?
I have no idea what this study says, if it even is describing costs and benefits. So I couldn't say. I mean, the company is not, we haven't put in an application to join EDAM. We haven't put in an application for the commission to decide whether we should join EDAM or Markets Plus. We've simply put in an application to join Markets Plus.
Understood, Mr. Taylor, but you did testify, correct, that Markets Plus provides more benefits overall and in relation to cost as compared to EDAM, correct?
Yes, I think in general that sounds correct.
To wrap up here, just a few additional questions. In your rebuttal testimony, Mr. Taylor, you claim that Advanced Energy United provided its answer testimony to advance their self-interest and their preference for CAISO markets, and in particular, the EDAM. Does that sound familiar?
Yes.
Can you describe what the self-interests of Advanced Energy United are that you're referring to here?
I would describe, from my view, not being that familiar with an association like AEU, that it is following the direction of its leadership, its board, and I assume its funders who desire a single West-wide market to further their own commercial interests. And in my experience over the last few years, the single biggest market means a market that starts with the California ISO and expands eastward. So that's why I believe your client is interested in the CAISO originated market plan rather than the SPP originated market.
Thank you. Last few questions here. In response to concerns raised by Mr. Turner in his answer testimony regarding potential federal policy changes related to greenhouse gas emissions, you characterize those concerns as speculative. Is that accurate?
Yes.
And it's true, right, that we just don't know right now if or how federal policy changes will affect the ability of SPP to implement an effective GHG tracking and accounting system for Markets Plus?
I think it's an answer that is going to apply. It could apply nationwide. It's the applying that potential problem is speculative to SPP and specific to Markets Plus, because you know, any state and any market could be affected by any change in federal policy. So that's why I think the whole idea is just speculative.
Would you say that it's likely that we'll know more a year from now than we do right now regarding whether federal policy changes in the Trump administration will affect the ability of SPP to implement an effective GHG tracking and accounting system for Markets Plus?
I don't know if we'll know more or know less than we do today.
Do you think we'll know more in 2028 at the end of the administration regarding whether or not this administration's policies will affect the ability for SPP to effectively integrate a GHG tracking and accounting system?
No, I don't. I have no idea.
I will wrap it up there. Thank you very much for your time, Mr. Taylor.
Thank you.
Thank you, Ms. Keene. Let's take a 10-minute break and come back at 10:45, and we'll start with you, Mr. Baressa.
Mr. Chair, is that 10 or 15-minute break? Are we coming back at 10:40 or 10:45?
I'm sorry, 10:40, 10-minute break.
Great, thank you.
Thanks. Mr. Barroso, you're up. Mr. Taylor.
Chair, and good morning, Mr. Taylor. How are you?
Good morning.
We've met before, but for the record, my name is Parks Barroso, and I represent Western Resource Advocates. Mr. Taylor, would you agree with me that Commission Rule 3753A identifies the 3 criteria that must be met in order for the Commission to find that a utility's participation in a day-ahead market is in the public interest?
Yes, I agree with that.
And if I refer to those as the public interest criteria, will you understand what I'm referring to?
Yes, I will.
And of the 3 public interest criteria, would you agree that Rule 3753A, Roman numeral 3, provides the cost benefit criteria that is applicable to the company's application?
It's one of the 3. I'm not sure if it's 3 or 2 or 1.
Just to make sure that we're on the same page here, that rule that we just referenced requires public service to show that Markets Plus has, quote, sufficient modeling and other analytical support, showing that the expected benefits of joining that market, including production cost decreases, reliability improvements, and emissions reductions, are likely to exceed the expected costs.
Likely, yes.
And has public service provided cost benefit modeling and analysis related to each of those benefits, namely the production cost decreases, reliability improvements, and emissions reductions that would result from participation in Markets Plus?
Yes, I believe we have.
And public services cost benefit analysis pursuant to this rule, is that what was presented as hearing exhibit 102, attachment MRG-4?
MRG-4, I would have to look at.
Sure, if we could.
You sure you're on the right witness, counsel? Your Honor, this is an exhibit of Mr. Grubert, whose testimony is being adopted by Mr. Bacher. That's the reason I inquire.
Mr. Barroso.
Yes, attachment MRG-4 is the 15-year rate impact analysis, but it's one that Mr. Taylor references extensively in his direct and rebuttal testimonies.
Yeah, and if you, well, and Your Honor, there was a revision to that document, and the version in evidence is the revision 1 of MRG-4.
All right, let's
how
pull
about
up.
this? Why don't we? Oh, sorry, Mr. Chair.
No, just pull up the document and keep going. We'll see where it leads us.
I think first maybe it'd be instructive if we could go to hearing exhibit 103, which is Mr. Taylor's rebuttal testimony at page 19. And here, Mr. Taylor, you're responding to whether the company met the requirements of Rule 3753A, Roman numeral 3. And there at line 15, you state that the results of the cost benefit analysis were provided as attachment MRG-4. Do you see that?
Yes, I did.
And so then just to go back, it's correct then that the company's cost benefit analysis in response to Rule 3753A3 was provided as attachment MRG-4.
Yeah, the 15-year estimated retail rate impact.
And so for purposes of determining whether public services application complies with Rule 3753A3, the cost benefit factor, should the commission be focusing its attention on the results that are included in that attachment MRG-4?
Yes.
And specific to the production cost decreases that are reflected in attachment MRG-4, those were derived from the Western Market Exploratory Group, or WMEG study, correct?
They're originally results from the WMEG study, yes.
And I believe counsel for the company was just referring to this, but for clarity of the record, MRG4 had originally referred to the savings from that WMEG study as fuel savings, but in the revised version, that label now states production cost savings. Is that right?
Yes, that's correct.
Thank you. Mr. Taylor, I would like to discuss that WMEG study with you now and your understanding of public services transmission rights and ability to export energy out of the Public Service Balancing Authority. Just to begin at a high level, would you agree that export capability out of the Public Service BA is a critical component of realizing the benefits of market participation?
Export capability out of the Public Service BA, import capability into Public Service BA, and import and export capability, or just capability within the Public Service BA, are all important to any benefits of a market with more than one party.
And so, not to the exclusion of those other benefits that you just listed, but specifically export capability is an important benefit or component of realizing the benefits of market participation.
It is one of those that I just described, yes.
And the original WMEG study had included an assumption that public service had quite a high volume of exports, and I think public service agreed that that assumption did not accurately reflect historical operations. Is that correct?
Yes, the original WMEG study results showed public service exporting more energy to other parties than we believed was reasonable. And that's why we reduced and had the what we call AP4 study performed. Was to
Thank you, Mr. Taylor. You predicted my next question, and just to clarify, that AP4 scenario, that is the WMEG alternative pricing proposal 4. Is that right?
That's right.
And in creating the AP4 scenario, a 900 megawatt export limit was imposed on the model. Is that right?
That's right.
But even then, after applying the 900 megawatt limit, the company found that the results from the AP4 scenario likely overstated production cost savings, correct?
That's right, because the 900 megawatt limit was a reasonable limitation to put, particularly in the 2026 cases, because it reflected about the highest levels of exchange that the company was having in the Weiss market.
And so the company applied, or excuse me, to correct that overstatement, the company conducted a study of likely transfer capabilities under the likely markets plus footprint and found that it was reasonable to further reduce that export capability from 900 megawatts to 478 megawatts.
Yes.
And then the company applied that adjustment in export capability to the modeled production cost savings, functionally reducing the 2026 savings to 53% of the amount studied in the APP4.
Yes.
And you testified that this adjustment was a germane and appropriate approach given the significant impact of export limits in the WMEG studies. Is that correct?
That's correct.
And I believe you also testified that export capability in and out of the public service BA is an important variable in the final WMEG result, and that scaling the benefits down based on the reduced export capability was a reasonable adjustment to account for the more limited participation of other entities outside the public service BA. Does that sound right?
It sounds right. Do you want to point me to the page of my testimony that you're reading?
Of course, if we could turn to hearing exhibit 103, this is Mr. Taylor's rebuttal testimony at page 27. And the lines I was referencing, Mr. Taylor, begin on line 14.
Yes, I agree.
Thank you. And is it still your belief, Mr. Taylor, that it was appropriate to reduce the export limit by 53%?
Yes, yeah, it was actually 47%, I guess, since.
Yes, thank you.
I think it's reasonable.
And changing topics just slightly, is it correct that the entirety of public services transfer capability to other markets plus participants that are outside the public service balancing authority rests on the company's transmission rights to and from the Four Corners area?
Yes, I agree.
And in Black Hill's testimony, not sure how to pronounce his name, Mr. E.G. testified that public service has only 30 megawatts of export capability through the Four Corners interface. Is that correct?
No, that's not correct.
You did not dispute that finding in your rebuttal testimony, did you?
I had some rebuttal of Mr. Aggie, but I don't believe it had to do with the 30 megawatts. What we used the 30 megawatts for in our export capability was an overall kind of average, because the company's rights in the north to south direction, which is the export direction, are limited based on rights that Tri-State has on the same path. So yes, those exports are lower when Tri-State's rights are being used, and are higher when their obligation is lower.
So I guess just to repeat back what I'm understanding from your answer, 30 megawatts is what you believe is the average, but there is a range that could be higher or could be lower than 30 megawatts.
Yeah, 30 megawatts is what we used as the component of the 478 megawatts. Yeah, it can be higher and it can't be much lower.
Could it be much higher?
Yes.
What would you say is the upper end of the range?
I believe we share with Tri-State 270 megawatts. So half of that is 135 megawatts. So our max Fiasco share could be up to 135 megawatts.
Thank you, Mr. Taylor. And to clear up some more confusion in the record here, that 478 megawatt adjustment that we were discussing previously, was that intended to include transmission connectivity internal to public services BA?
It includes our connectivity with Black Hills. That number's in the 200 something megawatt range. It does not include connectivity with the Tri-State loads and resources in our BA. So it includes a portion of transfer capability side of the VA.
And so just given that we've discussed that public service has an average export capability outside its BA of around 30 megawatts, could you explain why it was reasonable for the company to assume a 478 megawatt export limit on the WMEG study?
Certainly. The reason is the Black Hills, Colorado system and the portion of the tri-state system that are in the PSCO Public Service Company BA are expected to be Marcus Plus parties. And so we obviously included those capabilities as both import and export capabilities.
If the majority of transfer capability is internal to Markets Plus participants that are within the company's BA, do you have an estimate of the production cost savings that public service would derive from transfers just to participants outside the public service BA?
If I understand your question right, you're asking, did we perform a study specifically for our import and export rights in the Four Corners area? And if that's your question, the answer is no.
Mr. Taylor, if the majority of the transfer capability that we're talking about here is to Markets Plus participants that are within the company's balancing authority, isn't the company's application and the $20 million of cost associated to join Markets Plus quite a significant endeavor, only to provide what is effectively day-ahead optimization within the public service BA?
No, I don't believe so.
And why is that?
Beginning in 2026, public service won't be in a market until Marcus Plus starts in 2020. Later in 2027, the importance of being in a market with the Tri-State and Black Hills systems are significant. All three companies own and operate combined cycle and combustion turbine units that are going to be optimized in the day-ahead market, and that's going to provide value to all three of us in terms of the cheapest units being dispatched in day-ahead, and then of course real-time exchanges of renewable energy when one party is long renewables and being able to be absorbed by the other parties, no additional transmission cost. Those are all very valuable benefits of a day ahead and a real-time market, even just within the public service BA.
We can move on from this. Mr. Taylor, in your rebuttal testimony, you asserted that the company's application supports the conclusion that the company's submission is sufficient, especially as it points to and incorporates relevant and contemporary analysis. Does that sound right?
That part of your question was very faint, Mr. Brasso. I'm sorry. Maybe you can point me to the page.
Sure, and I can try to move my microphone closer. This was in your rebuttal testimony, hearing exhibit 103 at page 22. And beginning at line 12, you assert that the company's application supports the conclusion that the company's submission is sufficient, quote, especially as it points to and incorporates relevant contemporary analysis.
Yes, I agree.
And I'd like to drill down on that relevant contemporary analysis that you were referring to. If we could please turn back to your direct testimony hearing exhibit 101 at page 74. And so, Mr. Taylor, for the company's estimates of greenhouse gas emission savings, is it correct that you relied on the Western Flexibility Assessment, or WFA?
Yes, we relied on the WFA report to provide a guidance toward the relative GHG reductions that could be achieved in a market versus not being in a market. So it's not a total carbon savings, it's a relative between the two paradigms of being in a market versus not being in the market.
And that WFA study was conducted 6 years ago in 2019. Is that correct?
Yes.
Could you explain the footprint, loads, resources, and transmission connectivity that were modeled or assumed in that WFA study?
Not off the top of my head, no.
At a general level, do the assumptions from that WFA study exactly match the assumptions embedded into the WMEG study in terms of assumed footprint, loads, resources, and transmission connectivity?
No, I mean, a study done then compared to who was leaning toward what market, yeah, they're not going to be the same.
And do the assumptions of that WFA study match the current footprint of Markets Plus?
No.
Mr. Taylor, the company also applied a 53 or 47% downward adjustment to the greenhouse gas emission savings from the WFA study. Is that correct?
Yes.
Wasn't the 53% adjustment a fix created uniquely for the WMEG results based on the impacts of export limits on the model that was used by E3 in that scenario?
Yes, it's the 478 divided by 900.
And so we have two different studies with different assumptions that were created several years apart, but Public Service applied the same 53% adjustment to both.
Yes, we applied, we adjusted the WMEG study down because it had us exporting too much energy to our neighbors inside and outside our VA. And then we further adjusted that down to reflect the participation of the RTO West parties.
So just to summarize, that is a yes, correct, that Public Service applied the same 53% adjustment to both studies.
Yes, I say that right there on the line 12 on the screen.
Thank you. And Mr. Taylor, apart from the WFA study that we've been discussing, did the company provide any other modeling or analysis that quantifies the expected greenhouse gas emission savings attributable to the company's participation in Markets Plus?
No, the WFA was the resource that we used to show the additional carbon that could be saved in a market environment.
Thank you. And let's change topics. If you'll recall, Mr. Taylor, another aspect of Rule 3753A3 is the requirement to demonstrate the reliability improvements associated with joining a market. Does that match your recollection?
Yes, that's a part of it, yes.
And if we could turn to we're already on your direct testimony at page 42, please. And here in testimony at line 6, you state that Markets Plus will enhance short-term reliability through the Western Resource Adequacy Program, or WRAP program, and the must-offer requirements of the Markets Plus design. Do you see that?
Yes, that's at the bottom of that page, yes.
And taking the WRAP program benefits first, you already had extensive discussion of that with counsel for AU, Ms. Keene, and so I've only got a few questions here. Mr. Taylor, isn't it true that public service would be able to participate in the WRAP even if it did not join Markets Plus?
That's true.
So in other words, the WRAP is a program available to public service already and not developed specifically for Markets Plus participants.
That's correct. It is a requirement of Markets Plus participants, though.
And now for the must offer requirements, could you please define must offer requirement as it's used in your testimony here?
Certainly, it's on the top of page 43. Right, so there's a day ahead and a real time must offer requirement.
Is one way to summarize the must offer requirement that it ensures that participants bring enough resources to the market to meet their own load obligations?
That's a good summary.
And currently, Mr. Taylor, through the company's electric resource planning process here at the Colorado Public Utilities Commission, isn't it true that the company procures enough resources to meet its own load obligations?
I think the goal of a resource plan, and I'm not an expert on the resource plan, is to have enough capacity to serve peak load needs plus a planning reserve margin. These two must offer requirements are day ahead in real time. They're not long term.
I'm dropping it. Yeah, they're not what? The two requirements are day ahead in real time. They're not.
Right, they're not day ahead or real time.
Ms. Weisenthal, are we okay to move on?
Let's keep moving.
Okay. If we could turn up hearing or pull up hearing exhibit 900 attachment BT4. And Mr. Taylor, you'll see this was a discovery response that you were the sponsor of, and here you were asked whether the company performed or commissioned any analysis, including modeling, to estimate the reliability benefits from participating in Markets Plus. And your answer was that the company did not. Is that correct?
Yes.
Thank you, Mr. Chair. Just one moment while I check my notes. Those are all the questions I have. Thank you, Mr. Taylor, for your time.
Thank you, Mr. Barrasso. CEO, I have 30 minutes. You're on mute.
Sorry.
There you go.
Morning, Mr. Taylor. I don't think we've met before. I'm Jessica Lowry. I represent the Colorado Energy Office. Nice to meet you. Good morning. Okay, I want to start by asking you about governance. Has SPP specifically stated that if public service doesn't provide funding for the phase 2 funding, agree to the funding agreement by June 23rd, 2025, that public service will never be able to participate as a voting member?
Well, first, it's July 23rd.
Oh, sorry, I read my notes wrong. Thank you.
No, the participation as a voting member by July 23rd allows us to continue uninterrupted. Sorry. If we were to delay beyond that date, then we would apply to be voting members later, but may not be able to retain seats that we have because any associated work group or task force may be full and not accepting new members. So that's one of the risks.
Okay, so there is a mechanism for public service to become a voting member if they don't sign the funding agreement by July 23rd, right?
But we'll lose our capability to vote between then and between those 2 dates, obviously.
Okay, thank you. Then I want to move on to talk about cost and benefits. You didn't provide any additional information or evidence about benefits to joining Markets Plus in your rebuttal testimony, did you?
Any?
Yeah, you didn't provide anything new that wasn't in your direct testimony, right?
I believe that's correct, yes.
Okay. And do you agree that the cost benefit analysis changes depending on the number of utilities that joins Markets Plus?
Yeah, a cost benefit analysis will change based on virtually every factor that's assumed in it, including which parties are in the market and which parties aren't.
Okay. And if there's less members of the market, it will be a higher cost to each utility that's in the market, right?
Not necessarily. We had study results that showed lower benefits from the biggest number of participants in a market, and that's the EDAM case that was studied in by E3 in one of its cases that showed the company's production costs increased, and that was the largest market footprint study.
But would you dispute that in the case of SPP Markets Plus, if less utilities join, the cost to each utility will be higher?
Oh, the cost?
Yeah.
It's simple math. Yeah, the fewer megawatt hours applied against the same capital cost will increase the cost, yes.
Okay, thank you. Okay, can we turn to hearing exhibit, I believe it's the rebuttal testimony, which is
103. I've got it ready.
103, yeah. Okay, thank you.
Which page?
Page 20 at the top. So you're discussing WRA witness Kelly and her analysis to analyze cost benefits through 2032, which shows a net cost of roughly $30 million through 2032. Do you see that?
Yes, I do.
Okay. Do you dispute that analysis?
I dispute that by selecting simply the first 5 years, Ms. Kelly ignores all of the years following the 5, so years 6 through 15, which is what is required by the rule for our application.
Okay, but do you dispute that if we just look at the first 5 years, it would be a net cost of roughly 30 million?
I would have to review that to make sure I agree with the $30 million number.
Okay, but you didn't dispute it in your rebuttal testimony, right?
I did not.
Okay. And And what you did say was that if you look at the costs and benefits of the whole time period through 2042, it would be a net benefit of approximately 17.8 million.
Correct.
Right? Okay. Can you explain where that 17.8 million number comes from? Because I didn't see it in your direct testimony.
If I recall, and it's that same MRG4 exhibit that we started to go through. But yeah, it's in Mr. Gruber's direct testimony.
Okay, could we pull that up, please? So that's hearing exhibit 102, attachment MRG4. Thank you, Ms. Federicos. Okay, Mr. Taylor, can you show me on here where that $17.8 million number comes from? And maybe, Ms. Federico, could you zoom in a little bit? Thank you.
It's not showing up specifically on this page. If I could ask that this question specifically in the derivation of that be deferred to the next witness.
To Mr. Bacher?
Yeah, I'm sorry, to
Okay.
Mr. Bacher, yes.
Sure thing, thank you. Okay, but still looking at this, which is talking about rate impacts on the bottom line, it looks like it's a matter of cents that there'll be a positive rate impact for the first 5 or 6 years and then a negative rate impact. But it's just a matter of cents, right?
It's in the decimal places of cents per kilowatt hour.
Okay. Markets Plus hasn't provided certainty to the company about the costs of joining right now, have they?
By certainty, the costs of with the already executed phase 2 funders, those costs are certain, and adding public service to that list would provide certainty as to what our share of the $150 million phase 2 implementation cost is. I reference that as 18 to 20 million throughout my testimony.
18 to 20 million is the cost, but it's not certain yet because you don't know how many other utilities are going to join, right?
How many other utilities? Yeah, so I think the likelihood is that as additional utilities join, then public services share of the 150 will go down on a load ratio share basis.
Okay, thank you. And Ms. Federico, you can take that exhibit down. I want to go to something that you were talking with Ms. Keene about the requirement for public service to file an application to join an organized wholesale market by January 1st of 2030. Do you remember that?
I did.
Okay. And you talked about how if the commission approves this application, the company would join SPP Markets Plus in October, or the market would start in October of 2027. Correct?
Correct.
So the market would start in October of 2027, and the commission would need to decide on Public Services application to join an organized wholesale market sometime in 2029, right?
I think I said we went through what 18 months meant. And the company would decide if it was going to make an application to then join a statutory OWM or request a waiver or a delay.
Right. You talked about how the rules require the company to file an application 18 months before joining a market, which is mid 2028. And I'm estimating that the commission would decide sometime in 2029 whether to approve that application. Does that sound about right?
Yeah, that sounds in the event we filed an application and the transition of this process. Yeah, I'd agree.
Okay. So if that happens, the company would have at most 2 years of participation in the Markets Plus market before potentially joining another market, the organized wholesale market, right?
In that scenario, yes, and I would assume that if we made application to join a statutory OWM that quickly, that the benefits would be so dramatic to offset the exit cost of Markets Plus in 2030.
Okay, so there'd be exit costs of leaving Markets Plus. There's also the costs, the $18 to $20 million that the company would be paying to join Markets Plus. So that's 18 to 20 million plus that the company would be spending now for at most 2 years participation in Markets Plus, right?
The 18 to 20 million is collateral, and the collateral for a loan that starts getting paid off upon market start. So when I say exit fee, what I mean is the unpaid portion of that loan if we were to exit. So it wouldn't be the 18 to 20, it would be a portion of that after a couple of years.
Okay. Thank you. One last question. And this is talking about recovering costs through the ECA. So you might want to refer this to Mr. Bacher, but I wanted to ask you anyway. The company is requesting to recover the cost of joining Markets Plus through the ECA. And I wanted to know how that aligns with the benefits to customers when there are no benefits to customers for at least the first 5 years.
It aligns with, I mean, the administrative fees that we'll pay are based on transactions, and market transactions occur every day, much like fuel procurement and purchasing energy occur through the ECA. So I think it's still the right system to recover those costs.
Okay, thank you. I don't have any further questions, Mr. Taylor.
Thank you.
Thank you, Ms. Lowry. I have Climax next, 20 minutes. 20 minutes, Mr. Fanyo.
Thank you, Chairman. I think it'll be less than that because others have covered at least a lot of my questions. Good morning still, Mr. Taylor. My name is Richard Fanyo. I represent Climax Molybdenum and Company. Ms. Federico, let's go back to, if you would pull up hearing exhibit 102, attachment MRG 4. That's the cost benefit exhibit. And again, if you could, can you expand that one more notch? Yeah.
I can't
Yeah.
fit the whole
What?
screen, so which part are you looking for?
Well, one less notch then, so you can get the whole screen. Okay. Um, Mr. Taylor, I'm looking at the last line, number 21. It's called, the label is Delta. And that's the difference in, I believe this is residential rate impacts from year by year, taking into account the production cost savings versus all the various expenses. Do you see that?
Yes, line 21, the delta.
Yeah. Now, as you said, it's hundredths of cents. Actually, it's 0.0001, and then in 2024, I'm sorry, 2027 is 0.002, and then it goes back for a few years to 0.0001. See that?
Yes.
And that is, well, at 4 decimal points, 1/100th of a cent per kilowatt hour, right?
I believe that is correct, yes.
Okay. And then if we go out to years starting in 2030, it's actually 2034, it reverses to negative 0.0001 and continues at that level through 2042, correct?
That is correct.
So the rate per kilowatt hour is 1/100th of a cent of an increase in the first 5 or 6 years, and 1/100th of a cent per kilowatt hour decrease in the years after 2023, right?
Yes, except it's not 100th of a cent, it's 100th of a percent.
No, wait a minute. Take a look. Line 20 is the baseline cost per kilowatt hour. And line 18 is the cost per kilowatt hour with the cost of Marcus Plus, right?
Yeah, I think
Both
those, Mr. Fanyu, I believe as we get more in depth into these questions, I would suggest that or ask that you ask Mr. Bacher these questions.
Okay, I understand, and I am asking you because of your discussion of this exhibit and the cost differential on page 19 of your rebuttal testimony here in exhibit 103. So if you look on starting at line 14, actually line 17, it says during the first 5 years, there's a slight increase of approximately 0.0001 dollars or 0.0001 dollars per kilowatt hour in retail sales. That's what I'm referring to. Your description of this last line, 21 on MRG4. So it's cents, not percent, right?
Yeah, it's 0.0001 dollars per kWh.
Yeah, which is 1/100th of a cent per kilowatt hour.
Yes, that's true. Thank you.
Okay. So back to MRG4, what we have here is looking at the Delta line 21 going all the way across, a 1/100th of a cent per kilowatt hour increase during the first 5 or 6 years, and then a similar decrease in the subsequent years starting in 2023, 2024, excuse me, 2034, correct?
Correct.
So essentially it's a wash, isn't it? Early on, it's a very slight increase per kilowatt hour. And later on, it's an equivalent, very slight decrease per kilowatt hour, right?
Correct.
Okay. Now, we've had, but the net of that, as you've testified in your rebuttal, is that $17.8 million net benefit that you referred to Mr. Bucker, I believe it is.
Mr. Bucker.
Yeah. Is that a net present value of the net savings over the course of 15 years?
I'd say ask Mr. Bucker that question.
Okay, that's what I thought you'd say. Let me get my camera up here. Okay, now, if we go back to line 21 on MRK4, we've already talked about those very slight per kilowatt hour rate increases through 2031. Now, you've also discussed with the other attorneys the timing for the requirement to file an application for an OWM being 18 months before 2030 or mid 2028, right?
Correct, if we file for an application and not a waiver or a delay.
Okay. Okay, now let's look at MRG 4 for the years 28 and 29. We still have the increase occurring there, 0.0002 cents per kilowatt hour in 28 and 0.0001 in 29. See that?
Yes, on line 21 I do.
So the net cost, the net cost of joining Markets Plus is front loaded in the sense that it's more through 2032 than it is afterwards when the net benefits kick in for the rest of the period through 2042, right?
That's right, because the first 5 years has approximately $4 million a year of our share of the phase 2 funding.
Right. And actually you can get that by, if you look at starting on line 1, the revenue from retail sales, that's from the joint JTS application, Mr. Isles, JWA, attachment JWI 5. And that's the baseline of revenue requirements. You look at line 15, that's the adjusted revenue, including the SPP Markets Plus requirements. You take the difference of those two, and that's the increase every year through 2032. And then it goes the other way to be the reduction in overall revenue requirements through 2042. Have you looked at those numbers?
I didn't drive those, the JWI 5, but I understand the math between line 3 and line 15.
Okay. Subject to check, would you agree that the difference between line 3 and line 15 in 2026 is 3 billion? In 2027 is 5 million, 2028 is 7 million. In 2029, it is 5 million again. 2030 is 4 million, and 2031 is 3 million. Subject to check.
And you lost me there a little bit, Mr. Fanyo. Were you doing simple math between lines 3 and 15?
Yes,
Okay.
those are easily derivable by just subtracting 3 from 15 for each year, right?
Right. Just that. Yes, I agree.
And this is stretching a little bit for to alert Mr. Denman, but if you do those 6 years, the total difference in nominal terms is $27 million. So it costs 27 million more, those figures show, for the first 6 years of Markets Plus than it would without Markets Plus. Subject to check, would you agree?
Yeah, subject to checking each of those years. It's definitely increased cost.
Okay. So, but if we then overlay the timing of the OWM application, and let's assume that you decide that you would apply to join an OWN, that would lead to terminating the Markets Plus participation by the end of 2029, or in other words, by 2030, when the OWM that you had applied to join presumably would be approved and take effect, right?
Right, assuming we filed an application and not a delay.
Okay. So, and that would be true even if you filed for, even if you filed for a delay, say to 2032, there would still be a positive cost increase from participating in Markets Plus from what the figures shown on MRG4, right?
Right, the costs are increased into 2032, and then they start to come down.
Right. So we still have a Markets Plus cost increasing more than you've calculated the benefits to be through 2032 if Markets Plus ends then because you've joined an OWM, right?
Yeah, I'd agree. I agree with that.
So the only way that your cost benefit analysis shows net benefits to customers is if you don't join an OWM by 2032, but Markets Plus continues for some time and possibly as long as 2042, according to your calculations here, right?
I think I responded to Ms. Frederico. If we're the company to apply to join a statutory OWM starting by 2030, the benefits would have to be so great as to offset the additional costs we've been paying for Markets Plus and the prior to it, the loan being paid off in 2032.
You said Miss Frederico. Do you mean Miss Keene or Miss Lowry? You responded to who? Which attorney?
Oh, I'm sorry. Colorado Energy Office's attorney. I'm sorry.
Oh, Miss Lowry.
Okay.
Okay. I was not following you either. Could you repeat that?
And my apologies if it was Ms. Lowry, sorry, Ms. Frederico. We're the company to apply to join a statutory OWM beginning in 2030. The benefits of joining that OWM would have to be significant enough to offset the financing costs that we've paid or would have paid or would have to pay to exit Markets Plus in, before those financing costs are paid off.
Okay. The same would be for through 2032 if you applied for and received a deferral, right?
Correct.
Okay. So looking at the cost benefit analysis of joining Markets Plus that you presented in I always get this wrong, MRG attachment MRG 4, the only way that the net benefit that you have calculated and presented is the cost benefit, net cost benefit, is if Markets Plus continues through 2042, which means no statutory OWM during that period, right?
Right. The MRG4 was developed to comply with the rule that requires a 15-year retail rate impact. So the net effect over those 15 years is what's represented there in MRG4.
I understand your point about the 15 years. Not contesting that. My point has to do with what the first 6 or 7 years show about it costing more than the benefits and how that coordinates with the possible statutory OWM such that the present cost benefit analysis for Markets Plus doesn't show net benefits unless there's no statutory OWM taking effect by 2032. Isn't that correct?
From a pure cost standpoint, I think I agree with your question. As I said, and the company has said throughout this case, one of the primary reasons that we want to enter into a market like this is that we retain control of our ability to plan our transmission system, to plan generator interconnects, and to plan for new load interconnections. Because as everybody is aware, we have a lot of generation that we're going to add to our system over the next several years in order to comply with load responsibilities as well as our climate goals. And we're very concerned that the delays that are inherent and we've seen in the RTOs, is particularly around generator and load interconnections, gives us pause into turning over control of those activities to a third party and to an RTO. So while the costs are one component, the ability to plan and build are also important considerations that we'll have.
I understand all that. It doesn't change the results of the cost benefit analysis the company presented to meet the cost benefit requirement for a day ahead market in ERG or MRG 4. It doesn't change those numbers. I understand these other reasons, but the numbers still show that it costs more in the first 7 years to join Markets Plus, right?
Yes.
Okay,
Yes.
that's that. Yeah. You've already given the but I think, and I've read the but in your testimony. I understand all that, and that is a problem. I understand. So, but that's all the questions I have for you, Mr. Taylor. Thank you.
Thank you.
Thank you, Mr. Fanyo. Ms. King, I have 30 minutes for you.
Thank you. I'm hoping to take us quickly to the lunch hour.
It'd be great.
Good morning, Mr. Taylor. I'm Michelle King. We've met before. I'm here on behalf of the Colorado Energy Consumers. How are you?
Good. Good morning.
Okay, you're almost at a break. You've spent a lot of time talking this morning about the anticipated savings from joining Markets Plus, and I want to start there. The company estimates that annual production savings of 9.3 million in 2027, which then grow to 16.1 million by 2042. Is that right?
I believe that's correct, and I believe that was on the chart I was just reviewing with Mr. Fanyo.
Yep, and it's in your testimony as well. I can refer you if you need.
Why don't we, find me that page if you wouldn't mind.
Sure, it's Hearing Exhibit 101, page 53, lines 11, 12. You see that?
Yes.
Okay, and that's still your testimony today?
Yes.
Okay, and so in other words, 17 years out from today, we're expecting savings of 16 million with an M per year, right?
Yes. 17 years from now, yes.
Okay. And you agree that those savings, assume they materialize 17 years from now, cannot be viewed in a vacuum, wouldn't you?
Correct. Neither could, if those savings are significantly higher or significantly lower.
Okay, and there may be additional investments needed to bring those and other benefits from Markets Plus to fruition, right?
I think that's a fair statement. I'm yes, you asked that question. I'm thinking, our system is going to change year over year as we have new load, we have new generation, we have new transmission. The market is then going to solve to meet our load based on the changes in the system, every year based on those three factors changing every year.
Okay, Ms. Federico, if we can please scroll forward to page 56 of the same testimony. And Mr. Taylor, I'll refer your attention to lines 1 through 4 there, where you state that the key to public service maximizing long-term reliability improvements and emissions reduction is concurrently executing on construction of a transmission plan. Do you see that?
Yes.
Now, in your discussion with AEU counsel, Ms. Keene, I believe you said that the company has not quantified the potential transmission investment needed to maximize such long-term reliability improvements and emissions reduction. Is that right?
That sounds right, yes.
And I believe you said it's a plan to plan?
Yes.
Now, to put this in context, you're aware that the power pathway transmission loop to deploy the Colorado Energy Plan, that has costs in the billions with a B. Are you aware of that?
Yes, I am.
And in addition to that, the company is currently seeking a CPCN for transmission in the Denver metro area for approximately another billion, and that's in docket 24A 25A-007560E. Are you aware of that?
I'm not aware of the cost, but I'm aware that we have filed that CPCN.
And do you have reason to dispute those costs?
No, I don't.
Okay. And the just transition solicitation that's pending, that may result in additional transmission investment. Wouldn't you agree?
Yes, I think it will.
And any transmission investment needed to maximize reliability and emission reductions associated with Markets Plus, that would be incremental to the transmission projects we've just discussed, right?
It would be. We haven't included, nor do we have any today, transmission costs that are needed to implement Markets Plus.
So we don't know what they are, right?
I think this part of my testimony is talking about longer haul transmission, if you will, and I feel like the questions you're asking me are about maximizing the existing Markets Plus in our public service BA. Maybe we're thinking two different things.
And we can actually take this testimony down. What I'm trying to understand is if we are solving for production cost savings 17 years out of $16 million annually, and compare that against the order of magnitude of the types of transmission investments in the billions, that equation is one that we haven't filled in the transmission needs for what's required to maximize long-term reliability and emissions reduction. Is that right?
Right. I think long-term reliability improvements associated with connecting our system better with other Markets Plus parties hasn't been, we haven't, determined a cost savings specifically for that. But you're right, long-term or long haul transmission is expensive.
I'm sorry, I missed that.
Long-term transmission expansion is expensive.
Is expensive. Is that what you said?
I meant expensive, yes. Yeah.
Expensive with three E's. Not expansive.
Correct, expensive, yes.
Okay. You said that we've not calculated the cost savings from long-term transmission investments, but you also haven't calculated the long-term costs of that.
Correct.
Okay. You've identified in your conversation with Mr. Fanyo that you are concerned with delays in markets and want the ability, and I'm paraphrasing here, you want the ability to build transmission, plan and build transmission faster. Is that right?
Yeah, I believe our conversation was around the shortcomings or the delays that we see prevalent in the RTOs today, and that we're able to process and study particularly generator interconnections in a more timely fashion today because we retain control over our transmission plan.
Okay, and I believe that your explanation was confirming my point, which is that in retaining control, the company wants the ability to plan and build its transmission faster. Is that right?
Faster is definitely a benefit.
Yes. So yes?
Yes.
Okay. Now, is it your belief that if the company joins SPP Markets Plus, that participation in Markets Plus might greenlight or expedite approvals of transmission needed to connect with other Markets Plus members?
No, I don't believe it will greenlight anything. I mean, my understanding is we have requirements for getting approvals to build transmission, and those requirements will have to be met. We have to go through the same processes that we do today.
Okay,
Doesn't
I appreciate that nuance, Mr. Taylor. Do you believe that that would support the need to build those transmission projects?
It certainly will be a component of it, of the benefit side of a new transmission project that increases our connectivity with Marcus Plus.
And customers would benefit from long-term reliability and emissions improvements, right?
Oh, yes.
That's the goal.
Right, that would be the goal.
And wouldn't the company's shareholders also benefit from adding to rate base the investment needed to connect to other Markets Plus members?
Yes, when the company invests capital, then shareholders earn a return on a portion of that.
And so order of magnitude, whereas the company is projecting savings 17 years out in the tens of millions, the transmission investment that you identified is as expensive, would likely be on the order of billion, right?
I can't say what order of magnitude a transmission plan would be, but transmission can be expensive.
Thank you, Mr. Taylor. I have nothing further.
Thank you, Ms. King. Holy Cross, do you have, I think you're down for 15 minutes. Did you say that was more like 30 minutes? All right, maybe we'll break for lunch and come back at 12:45. Does that work for everybody? 12:45. Thanks, and see everyone at 12:45. All right, Mr. Taylor, are you out there? Welcome back.
There he is. I was going to say, Your Honor, he should be ready.
I have next Holy Cross. Mr. Sopkin, did you have a preliminary matter? You're muted.
I thought I was next on the matrix, but if I'm not, I'm not.
No, I think Holy Cross.
Okay. All right. Thanks.
I have Mr. Detsky. I have 15 to 30 minutes for you.
Mr. Chairman, I also have Mr. Sopkin ahead of me on the matrix. I'm not sure.
Oh, all right. Mr. Sopkin, I guess I screwed up the columns.
Well, Your Honor, for what it's worth, the revised matrix we filed did have Black Hills next. I'm not, but you've got it sorted. Thank you.
Yeah, all right. I guess I had the older version. Go ahead, Mr. Sopkin. I have 20 minutes for you.
Thank you, Mr. Chairman. Mr. Taylor, we know each other.
Yes, we do. Hello.
I hope you're doing well. Sorry to be on the other side of the aisle, as it were. But I promise this will not be like the dentist. Mr. Taylor, I'd like to start with your rebuttal testimony, hearing exhibit 103 at page 46. Looking at lines 17 through 19, you indicate, furthermore, Mr. Agee suggests that the export capability of 478 megawatts may need to be reduced to reflect the company's actual ability to sell off its system. Do you see that?
Yes.
And would you agree that that figure should be reduced to 30 megawatts?
To reduce to 30 megawatts?
Yeah, and maybe it's best if I pull up another exhibit. You recall the cross-examination of Mr. Barrasso, in which he was talking about the actual export capability for Black Hills in the Four Corners region. Do you recall that discussion?
Mr. Barrasso talked about the export for public service, not Black Hills.
I'm sorry, the export capability of public service. I stand corrected.
Oh, yeah. Okay.
And if we could pull up, I believe it's in boxes, hearing exhibit 701. And I will represent to you, Mr. Taylor, this is your work paper. If we could make it a little bigger. Work paper JCT 01 dash 250127 production cost evaluation. Do you recognize this document?
Yes. Yes, I do.
And if we could just scroll through the document so that Mr. Taylor can see it. So, Mr. Taylor, this is produced as one of your work papers, correct?
Yes, it is.
Okay, if we can go back to the first page. And Your Honor, I would seek admission of this as an exhibit.
Any objection?
No.
So moved.
Mr. Taylor, can you tell me what the meaning is of under the row FC, the far right of that says the number 30?
That's the FC stands for Four Corners, which is series of transmission in and around it's called the Four Corners area, but it's Four Corners, San Juan, and Shiprock are the substations, and there's transmission lines coming into and out of that area from different directions.
And Public Service Company's export capability in the Four Corners region is 30 megawatts, or I believe you said an average of 30 megawatts.
30 megawatts is a proxy for that represents that we have secondary rights on to serve all the way down to Four Corners, because while we own a share of that path with Tri-State and WAPA, our share with Tri-State gives Tri-State superior rights to use that transmission first to serve its load in Southwest Colorado. And so when the load in Southwest Colorado is high, public services capability to use our rights is lower, and vice versa. When the load is lower, then we have more capability to use.
But nevertheless, the 30 megawatts is a fair representation of what you believe to be Black Hill's export capability in the Four Corners region is on an average basis.
I think it's public services conservative view of its rights.
Okay.
Use something like 30 megawatts.
Okay, and then with regard to the figure listed for SPP RTO, would you agree that SPP RTO is a market that does not have a defined market-to-market coordination structure with Markets Plus?
Well, neither SPP RTO in the West nor Markets Plus are up and running yet. So it would stand to reason that there's no market-to-market optimization between them.
And for the same reason, the coordination between Markets Plus and the SPP RTO is not included in the current Markets Plus or SPP RTO tariff. Is that correct?
I'm sorry, Mr. Salkin, can you restate at least the beginning of that question?
Would you agree that the coordination between Markets Plus and the SPP RTO is not included in the current Markets Plus or SPP RTO tariff?
Correct. I don't recall seeing any market-to-market optimization in either of those tariff filings.
Okay, and then with regard to the tote 3, would you agree that that is not a meaningful trade path with the announced non-public service BA Markets Plus participants?
I'm thinking through the tote 3. Tote 3 primarily connects the what's called the WAPA system with Markets Plus, or I'm sorry, with the Colorado system. I'm not sure, besides the 60 megawatts of tote 3 rights that the company owns, if there are other rights that are owned by Markets Plus participants that could be used. But the 60 megawatts there is the PSCO owned transmission rights on tote 3.
Okay. So when you were asked about this before, you talked about in terms of optimization that you would want to include import and export capabilities And that includes the combined cycle gas capabilities of potential Market Plus participants, which would include Tri-State and Black Hills. Is that correct?
I did. I think I mentioned, at least in the context of that question, both combustion turbine and combined cycle gas, especially as it terms the day-ahead market optimization and unit commit.
Okay, so CT benefits as well. Would you agree that the optimization benefits that you're talking about here depend on Tri-State and Black Hills signing the Markets Plus participation agreement?
Specifically to the capacity, both what's called purchase capacity, which for Black Hills is 160 megawatts. And then the sale capacity, which is export, which is 288. That obviously supposes or presupposes that Black Hills is in Markets Plus alongside public service. Now, if I can continue
Sure.
We did not we did not incorporate any Tri-State transfer capabilities in this table. We were being conservative, and of course, Tri-State serves, load, and has generation inside of the public service BA, which would be additive to this table. So I think this table is conservative in that respect in terms of our import and export capability.
But in terms of Black Hills and the 160 megawatts and 288 megawatts, is that counted in the company's quantification of benefits of joining Markets Plus?
It is for the company's quantification as having Black Hills in the market with these capabilities between our two systems is a component of the production cost savings that accrue to Public Service Company of Colorado. Now, it does not incorporate benefits that Black Hills 160 megawatts and 288 megawatts of capability between itself and the Public Service Company system provide benefits to Black Hills. These are just public service benefits, not Black Hills' benefits.
And if Black Hills does not end up deciding to directly participate by signing the participation agreement, has Public Service Company provided a quantification of benefits without those Black Hills benefits that you just described?
No, we have not.
Okay, so we don't know from this record how much the quantification of benefits might be reduced.
No, but I will say, Mr. Sopkin, that and this is in my rebuttal testimony, I think, just before the page that you referenced, so starting on page 45, that if Black Hills is to remain in the Public Service BA, it's going to be in Markets Plus, whether it's its own market participant or whether it signs a contract with either Public Service or a third party to be its market participant. It's a requirement as long as Black Hills remains in the Public Service BA.
Let me ask you a question about that. Is Public Service Company as the balancing authority required to register the load and generation of Black Hills Colorado Electric?
If Black Hills does not register the loads and the resources, they will be registered to Public Service Company pursuant to the Markets Plus tariff.
And would, in that scenario, Black Hills Colorado Electric be required to bid its load and generation into Markets Plus?
In that scenario, the loads and the generation would be managed by Public Service, and I would assume that Black Hills and Public Service would want to have a contract to effectuate Public Service being the agent for Black Hills.
Is that in effect saying Black Hills Colorado Electric will be in the market no matter what?
Yes, I believe I made that clear, as long as Black Hills Colorado remains in the Public Service BA.
Okay. We talked, or Ms. Keene talked to you about Rule 3753A, and I won't repeat the rule, but it has to do with optimizing the efficient dispatch, exchange of energy, and unit commitment between markets. You recall that discussion?
Yes.
And I'm going to ask a more specific question than Ms. Keene did. Does Public Service outline in its Markets Plus filing the plan in place to optimize the unit commitment between Markets Plus and other regional market constructs proposed to operate in Colorado?
Did we specify the unit commit procedures between the different markets in Colorado?
Well, it's whether there's a plan in place to optimize the unit commitment between Markets Plus and other regional market constructs.
Yeah, well, I think that neither the Markets Plus tariff or the RTO West tariff specifically describe an optimization between those two markets, and I think I admit in my direct that the market optimization between the two is not optimal. We think that real-time dispatchable transactions will provide some opportunities that we're going to lose when the Weiss market goes away, but it's not a full unit commit. It's two different markets under two different tariffs.
Do you have a date in which optimization will occur between the markets?
No, I do not.
Okay. So on the cost side of the cost benefit analysis here, would you agree that Black Hills, Colorado basically has two choices? First is to participate directly on its own with Markets Plus. And the second choice is Black Hills, Colorado Electric participates indirectly because the balancing authority has joined Markets Plus. Those are the two options.
The third option is that Black Hills hires somebody else to be its participant.
Well, with regard to the direct participation option, you would agree that Black Hills would be responsible for its share of Public Services Markets Plus costs under that scenario.
I'm sorry, were you asking when Black Hills is its own market participant?
Well, it's directly participating in Markets Plus through signing the participation agreement.
Yeah, I think that Dr. Dalkey asked me to address that question in my rebuttal testimony, and I did. And I think the short story of that is, if Black Hills or Tri-State, a direct market participant and thus has their own phase 2 fees, then when we settle with both Black Hills and Tri-State in our ancillary services, we will back out. I'm trying to remember exactly how the accountants told me, but neither Black Hills nor Tri-State will pay twice. You're already paying your share of phase 2, and you will not be paying the share of phase two that public service has that is relative to your load. You're only going to pay once, not twice.
Okay, well, let's talk about the indirect participation side. If we could pull up hearing exhibit 700, attachment EME-2, and this is response to Black Hills Discovery 1-6. If we could scroll down to 1-6.
This is all that's on this one. 1-4.
Okay, is there another one that says attachment EME-2 PSCO response to BHCOE 1-6?
There's only one EME-2. I can see if there's another that's responding to 1-6. Hang on.
Oh, I'm sorry. It is EME-3. That's my mistake. Okay, and here, Mr. Taylor, Black Hills asks the question, does public service anticipate allocating any of its costs associated with implementing or participating in Markets Plus? I'll skip the parenthetical to its balancing authority customers, and your response is public service anticipates incorporating the cost to participate in Markets Plus in its FERC-approved production and transmission formulas, which would allocate a share of the cost of Markets Plus participation to non-retail customers in the balancing authority. And then whether any particular cost is included in the production or transmission formula will be a function of the type of cost and the FERC account to which it is recorded. You see that response?
Yes, I do.
And these are the costs that Black Hills Colorado Electric would face if it doesn't directly participate, it's indirect participation, correct?
You know, I think we clarified this more on page 45 of my rebuttal testimony, and really the function of the type of cost was relative to what you and I just discussed a few minutes ago, which is, for example, if Black Hills were a phase two party and incurring its own costs, we would not include Black Hills' share of public services costs because they're already
okay.
Getting those costs.
Fair enough. And the reason I showed you this is you referred back to this response to our discovery request 1-7, which should be the next exhibit, hearing exhibit 700 EME-4, I guess. And your response here just refers to the company's response to Black Hills Colorado 1-6, but I'm not sure that answers the question, so I want to ask it to you right now. The question is, if Public Service Company proceeds to execute a Markets Plus Phase 2 funding agreement, and for some reason PSCO does not fully integrate into Markets Plus does not proceed to go live, or Markets Plus ends prior to the expiration of 5 years, will PSCO seek to recover its phase 2 funding costs or any sunk implementation costs from its balancing authority customers? And so my question to you now is, what are Public Service Company's financial obligations under the phase 2 agreement if it withdraws from Markets Plus prior to implementation, or if Markets Plus is not successfully implemented?
Well, public services obligation, if we unilaterally terminate our participation in Markets Plus at any point after we sign the phase 2 funding agreement, that collateral turns into an obligation. If Markets Plus never gets off the ground, if the market never goes live, I would presume that's going to be because the parties in Markets Plus decide to terminate it before it starts. And at that point, we will have, their SPP will have drawn on some level of that funding that we've provided, the collateral for. So we're going to pay whatever that level is at that point. And I know you had a really long question.
And in terms of either of those scenarios, will public service be recovering the phase 2 funding costs or sunk implementation costs, including IT investments, from balancing authority customers?
I'm not an expert on our formula rates for production and transmission, but if I were to, I'm not supposed to assume, so I'm not going to assume.
So your answer today is you don't know whether balancing authority customers would end up being allocated a portion of those costs as described in this discovery request.
Your Honor, I object. That mischaracterizes the answer. I think the answer was he's not willing, that Mr. Taylor's not willing to speculate to answer Mr. Sopkin's question.
Well, then I'll rephrase. If you do know the answer, please say it now. What is the allocation?
I don't know how costs like this are allocated in our FERC formula rates.
Okay. I have no further questions. Thank you.
Thank you, Mr. Sopkin. Mr. Detsky, I have 15 to 30 minutes.
Yes, correct. And Mr. Chairman, I now realize after this snafu that you were talking to me right before the lunch break, and I didn't catch that. So I apologize and confirm your question of an hour ago. Mr. Taylor, Mark Detsky, on behalf of Holy Cross, you and I have known each other for as long as I've been in this business, but it's good to see you again.
Hello, Mr. Detsky.
I'm going to be dancing around, but hopefully asking unique questions to you to confirm a few things on the record on behalf of Holy Cross. And you just had an exchange with Mr. Sopkin for Black Hills, which is the utility that's interconnected with Public Services Balancing Area Authority. Is that correct?
Yes, it is.
Holy Cross is also a utility interconnected with Public Services Balancing Area Authority, correct?
That's correct.
And one distinction to make, though, between these two utilities is that Holy Cross is a wholesale energy customer of Public Service, but Black Hills is not. Is that correct?
Yes, I'm Black Hills and Public Service buy and sell power with each other, but in terms of our requirements.
Correct. Correct. Thank you for that clarification. And to level set, Markets Plus is not a regional transmission organization or RTO, correct?
That's correct.
And you've testified that one of the benefits that you see to joining Markets Plus is that Public Service will still control its transmission system even after entering Markets Plus. Is that correct?
Yes, that's true.
And other utilities that are part of the Public Service Balancing Area Authority, like Black Hills and Holy Cross, will continue to control their transmission systems as well. Isn't that correct?
Yes.
And Markets Plus will also not change Public Service's control of its interconnection tariff, or OAT, correct?
It's generator interconnection, correct.
And nor will it change Black Hills' control of Black Hills' interconnection procedures, correct?
That's correct.
And Markets Plus will not engage in transmission planning and building new transmission lines in Colorado. Is that correct?
Yes, that's correct.
And in fact, you noted in your direct testimony that SPP, as the Markets Plus operator, will have no role as a regional transmission service entity. Isn't that correct?
That's correct, yes.
Okay. So Markets Plus instead is about control over generation dispatch with rights of use that others already have on the transmission system. Isn't that correct?
Yeah, so SPP is the Markets Plus market operator, takes the transmission and the generation that's offered into Markets Plus, and it as terms transmission, it has a wide area view of the whole Markets Plus transmission system, and will allow its market engine to solve and dispatch energy across that footprint, so long as that dispatch doesn't exceed, an operating limit on the transmission system.
Okay. And that's what makes it different from something like the SPP RTO that will have full control of the transmission system.
Yeah, partly so, because SPP is also not they're not the transmission service provider in Markets Plus, so they're not selling transmission that's owned by Public Service or any other party.
Okay. And you had some conversations already that I will not belabor about Public Service still retaining control of its electric resource planning and its resource adequacy requirements, correct?
That's correct.
And you talked with, I believe, Ms. King about joining the RAP, and the RAP has a separate resource adequacy requirement than Colorado. Is that correct?
Right. RAP that's what RAP was designed for, was to develop a regional or a potentially west-wide resource adequacy.
And when you say joining RAP for a public service, you're referring to joining as a binding member of RAP, correct?
By joining, I meant, executing the appropriate contracts and implementing our participation in RAP that has a program that goes binding. I believe now it's in sometime in 2028.
And when RAP uses the word binding, they mean that you have to make a showing, I think it's 7 months in advance, that you're meeting the RAP resource adequacy requirement, correct?
Correct.
And if a utility does not make that showing, there can be penalties, correct?
Right. The utility can meet the showing and have excess and sell to other RAP members, or if it is showing not to be meeting its full PRM, then the utility would try to contract with one of the other RAP participants who's long to meet that deficiency, and then there wouldn't be any financial consequence.
But if a penalty is incurred, those can be pretty steep in the RAP, correct?
Right. It's all based on cost to build a new generator.
Right. So you can have a penalty that's up to the cost of building the next marginal generation unit on the system, correct?
Right.
Okay. Thank you. I want to now turn to your rebuttal testimony, hearing exhibit 103 at page 45, Ms. Federico. And I want to go over some of these same responses you gave to Black Hills, but maybe I think I have a different take than what you were discussing with Mr. Sopkin. At lines 14 and 16, you're responding to these questions that you talked to with Black Hills and Tri-State. And at line 14, you say, if one or both acquire market participant services from Public Service would register the generation and load and assign those costs back to the entity. Do you see that?
Yes, I do.
And here you're referring to, when you say one or both, you're referring to Tri-State and Black Hills, correct?
Correct.
But those entities, as you just discussed with Mr. Sopkin, they could also seek those services elsewhere, correct?
That's correct.
And these statements that you make about Tri-State and Black Hills, they could also apply to Holy Cross, isn't that correct?
I assume they could, but I would note that Public Service and Holy Cross have a load serving a power sale contract, and I don't know the extent that these costs or any future public service market participation is contained within that power sale agreement. So I'm not exactly sure.
So when you onto the bottom of this page and onto the next page, you talk about whether or not Tri-State or Black Hills join or go on their own. In any case, they will not be required to double pay, nor will they receive Markets Plus services at no cost. Do you see that?
Yeah.
So when you say double pay, and you were talking about backing certain costs out of a formula with Mr. Sopkin, you mean that each of these utilities ultimately will pay only those costs that they would otherwise have to pay as a member of Markets Plus themselves, and no more or less. Is that correct?
Yes.
And then turning down to page 46, the next page, and onto the start of page 47. Thank you, Ms. Federico. You're responding here to Mr. Eggy, and you state that despite the limited export capacity of the Public Service Balancing Area Authority, quote, what Mr. Eggy does not state is that the capability between the public service system and the Black Hills system will allow Black Hills to benefit greatly from Markets Plus because it will be able to import generation directly from the market to serve its Colorado load, and also be able to offer and sell its Colorado generation into the market with no additional transmission service costs in either direction. Said another way, Black Hills benefits of participating in Markets Plus will primarily accrue from the direct interconnection and transfer capability between our two systems. Did you see that?
I do.
Okay. I want to discuss this with you just a bit. You testified that Black Hills is going to pay these Markets Plus costs either way, no more nor less than what it would, whether or not it's in the public service, taking service from public service under Markets Plus or taking service on its own, correct?
Correct.
And so here what you're saying is that either way that happens, Black Hills is also going to be able to greatly benefit in either scenario. Is that correct?
Yes.
And is that great benefit due to the capability between the two systems?
It's due to a couple of reasons, Mr. Detsky. First, Black Hills is not a network service customer of the company, and Markets Plus does not have a specific transmission service charge. So what I'm getting at in this answer is Black Hills can export into Markets Plus or import from Markets Plus using the public service system without paying a specific transmission fee for those day ahead and real-time transactions. Instead, it and all other market transactions pay the market transmission use or MTU charge that I described in my direct testimony, and that is so that the market can use the transmission system on a day-ahead and real-time basis without having and that'll increase the efficiency of the market, because then customers don't go and have to go and buy hourly or daily service. That is a block transaction with scheduling requirements and things like that. So that was the end. That's really the point I'm trying to make.
Okay.
Specifically, it refers to Black Hills.
In the market transmission use, is that the charge that you will say is going to be put into the formula rates?
I think the net, that's a tough question for me to answer because I'm not the formula rates guy. Like I explained to Mr. Sopkin, the transmission formula rate, but I think the net effect of the Markets Plus transmission use is that all transactions pay for it, and then the transmission providers are the recipients of those payments. So our expectation is that on a net basis, there's no impact to either retail or wholesale customers.
Okay. And when you're saying that this is all because of the capability of the systems, then the capability you're referring to is the ability of Black Hills or Holy Cross to schedule power or nominate power into Markets Plus?
Correct. Right. You offer resources to serve load.
Okay.
And the transmission system delivers that.
Is there another benefit that and we can we can take this exhibit down, Ms. Federica. You also went through this, we can pull it back up, this EME3 discovery response that we just had up. Is another benefit to Black Hills or to any entity like Holy Cross that's taking service under these formula rates that lower production costs over time will accrue to those rates? In other words, there'll be lower production costs and the road not taken over time?
Over time, there will be lower production costs. I'm not sure what you meant by the road.
I mean, is that part of the great benefits that you were talking about to Black Hills?
Oh, yeah. Black Hills will receive lower production costs through its participation in Markets Plus, yes.
And that would also apply to Holy Cross, correct?
I believe so, yes.
Okay. And you testified, I believe, with Ms. King earlier that your analysis is showing that cost benefit analysis sort of reaches a level of about $16 million annually in your formula. Is that correct?
It's 17.8 million.
17.8 million. And
please ask Mr. Not Mr. Burman. God, the other guy. I'm sorry, I keep forgetting. Mr. Bacher.
Well, I want to stay high enough level, hopefully, that you could answer, Mr. Taylor, which is that when you're looking at that 17 million cost benefit, you're saying that you take all the costs that are going to go into those formula rates and you have a net benefit of $17 million annually accruing to all PSCo customers, even after paying those costs.
It is the difference between the benefits and costs over 15 years applied to the total system. So I think the answer is different than the question because it's total system and it's not broken out retail and wholesale, and it's the accrued net after 15 years.
Okay, so I think you might have answered it, but I'll just ask the final question then. So you're saying that those benefits, they're going to be commensurate and flow to both wholesale and to retail customers. Is that correct?
Correct. I mean, different wholesale customers, depending if they're buying actual production services from us or not. It just depends what level of production and transmission, right? We have transmission only customers. We have transmission and production customers combined, and then we have kind of hybrids like Holy Cross.
Right. But for your analysis, you were looking at production costs, benefits.
Correct.
Okay. Thank you. That's all the questions I have.
Thank you, Mr. Detsky. UCA, I have 60 minutes and it's 1:30.
Thank you,
Mr.
Mr.
Wittersheim.
UCA waives its cross-examination of Mr. Taylor. Thank you.
Thank you, staff. I have 15 minutes.
And Your Honor, staff is also going to waive its cross-examination of Mr. Taylor.
All right. I don't think Commission Counsel had any questions. Commissioner Gilman.
Sure. Hi. Yeah. Good afternoon, Mr. Taylor.
Good afternoon, Commissioner.
I wanted to go over some of the costs with you of joining Markets Plus, just to make sure I understand what the costs are coming from and how they're charged. If that works. So to my understanding, the company's already spent approximately $2 million on their share of phase one process. Is that accurate?
Yes, a little about almost 2.2 through the end of this month.
Okay. And what did those costs cover, just so I understand?
They were a kind of two components, but in order to engage in conversations about starting a new market by SPP RTO employees, they are required to separately account for those costs so that the SPP RTO members aren't paying for SPP's expansion into a different area. And so the SPP came up with a cost estimate to implement the first phase of Markets Plus. And then we and several other companies signed a phase one participation agreement or phase one funding agreement, paid a flat charge to SPP that accounted up from that point until SPP made its filing at FERC back, 14 or so months ago. And then had a continuing budget beyond that we paid our share of on a monthly basis from the time of the FERC filing until phase one ends, which should be any day now, should be before the end of this month.
Okay. And then the phase two costs for Markets Plus are anticipated to total approximately $150 million. Is that correct?
That's correct.
Okay. And now, since this was filed, I believe there have been some updates, including the expected date of operation being delayed to October 2027. Have any of those changes had any implication to the expected phase two costs, or do you understand those to still be as accurate as you understand?
No, I have not heard of any changes to the $150 million. And any change to that amount pursuant to the phase two funding agreement will require SPP to come to the phase two funders, present its need to increase its costs, and then work that into a budget if the phase two funders and SPP all agree that it's a reasonable cost increase. So there's an intentional bar to limit the ability of SPP to simply increase its costs without the Markets Plus funders going along with it.
Okay, and I feel like I've generally saw it portrayed as approximately $150 million, but it sounds like that is a more firm number.
It's 150 million unless it changes. As 150 million is the number in the phase two agreement.
Okay. And then as I understand it, the 150 million would be recovered through an administrative fee placed on market transactions going forward?
Yes.
So then a public service company as a participant in the market would pay those as you transact in the market?
Yes, the financing costs and the actual ongoing markets plus costs will both be collected under the same market administrative charge. We've estimated that the market administrative charge itself is about 10 million, and then for the first 5 years or so of the market start to pay off the finance, it would add 4 million a year for those 5 years.
Okay, yeah, so there's the actual 150 million, which gets split up, and then there's the financing charge on the 150 million, right?
The 100, yeah, the split up of the 150 is collateral. So I believe in the testimony talk about our share being between 18 and 20 million dollars. So we'll be providing collateral for that. And then when SPP will be drawing on its loan agreements with its third-party bank. And then when market starts is when SPP will start paying off the loan. And instead of holding collateral, we'll be paying our share, and our collateral will be dropping as our amount of the loan is decreasing as it's repaid.
Okay. And then help me understand what comprises of the $150 million. Like,
it's what is needed to start a market in 2.5 years. Some staffing. SPP is going to hire a number of new people, both market design and software engineers and operators and market monitoring unit personnel. So labor is going to be a big piece of that. Software will be a big piece of that. I don't have the specific breakouts of those, but it's it's a large version of putting together a brand new product, and that's the cost estimate.
okay. And then SPP is concurrently building out its plans for the SPP West RTO, right? What, if any, overlap is there in personnel or IT systems or any of this expense that serves both needs, or are all of these costs entirely specific to Markets Plus?
That's a great question, Commissioner. I think to the extent that a computer or a server or a person spends part of their time doing RTO work and part of their time doing Markets Plus work, they're going to allocate their time accordingly, and systems as well, because on the RTO side, SPP can't spend money for Markets Plus and charge RTO customers, and vice versa. So they'll be sharing systems, sharing time, sharing allocators.
But is it understood that whatever is being invested in, whether that's personnel or systems to stand up Markets Plus, has some use in the RTO West, or is it generally seen as totally separate effort?
I think it's, functionally it's totally seen as a separate effort, but if there's people who are spending part of their time of their day, right, on one or both of the systems, that they're going to charge their time appropriately.
Okay. And then in addition to the 150 million and paying back that and the financing charge, the company also anticipates administrative fees on its market activities will be about $10 million a year.
Correct.
Okay. And what does that pay for? That's separate from standing up the market and the personnel.
That's that's just the ongoing. SPP has a budget that they will prepare for market start, and it will be divided out by the expected transactions in the market, so all load and all generation and all wheel throughs and things like that. And they'll determine a rate, which is those dollars divided by all of those megawatt hours, and charge that to all market transactions. And that is the people they hired, right, to develop and start Markets Plus are going to be the people that also run the market. So the 150 is recovering the systems and the people up to market start, and then the admin fee will cover the same services and products from that point on a going forward basis. So it's the cost to run the market.
Okay.
And I mean, if I can add, you know, in relation or in comparison, SPP RTO, I believe, has an annual budget in just shy of 300 million a year. So Markets Plus 70 is about 75 million a year. The whole RTO is about 300. So it's fractionally smaller, but makes sense. It doesn't provide all of the same tools and services that the full RTO does.
Okay. Let me get to my next question here. And then so the estimated financing costs are about $4 million annually for the first 5 years. Is that accurate?
Yes, it is.
Okay. And what's your share of the financing costs based on anticipated market activity or sales, or how does that get determined?
It's based on what's called net energy for load, which is essentially all of the energy that is served within your balancing authority area. So for public service company, our NEL is 38 million megawatt hours, plus or minus. And it's made up of, you know, our total retail load, plus our requirement sales to our wholesale customers. And if you add all of that up, that's what our denominator is, so to speak. And at the time we made this filing back in February, we were about 13 point. If you added public service to those who had already committed to sign the phase 2 funding agreement, our share of the total cost is about 13.3%. Now it's gone down some because Puget Sound Energy just a couple of weeks ago signed the phase 2 funding agreement. So our amount is under 13% now.
Okay, so if additional load comes in or commits or signs the phase, it sounds like signing the phase 2 funding agreement is the magic.
It is. That's
so if new load does that, your proportional share shrinks, which shrinks both your portion of the financing costs as well as your portion of the 150 million?
Yes, it does.
What about the 10 million a year in administrative costs?
It would this about the same, right? Because the total annual budget is then allocated over more load. So functionally and proportionally it'd be the same.
Okay.
Our share would reduce.
And what's the plan as you understand it for kind of later entrance into Markets Plus? I mean, I presume there is a intent to grow it to achieve economies of scale here. So how does the original 150 million and the financing charges that kind of the first to agree and sign the phase 2 funding agreement are signed up for? How does that work with any newer market entrants that come in after the fact?
Thank you. That's a great question. It's actually a bit of a bragging point, I guess, because once you've signed your phase 2 funding agreement, you know, you're committed. And if you walk away from it, then you're holding the other party's whole by the collateral that you put in. So in the same vein, when a new party comes in and signs the phase 2 funding agreement, it's it's Exhibit 1 to the Phase 2 funding agreement. We'll reallocate. We'll add a new company in with their new NEL, and it'll reshuffle the allocation of the 150 million. And all of the parties who were already, funders, their share will go down. And so their collateral requirement will go down to accommodate the new member. So I hope that answered your question.
It all makes sense probably for the first 5 years. What happens if it's after the first 5 years of paying off the 150 million?
Oh, so like in 2032? I mean,
Yeah, sometime after.
I'm just not familiar enough with, thinking about that in terms of the existing Phase 2 funding agreement. I'm thinking about that funding agreement more in terms of, now versus 6 months from now. So.
Okay, so you're not sure what happens if someone joins, after the 5 years wind down of the 150 million.
Yeah, I don't know how long if a party signs the Phase 2 funding agreement, but then doesn't want to start the market or start in the market until later, like say a year after the market initially starts, that party is still going to pay its Phase 2, the financing piece during that 1 year between when the market starts and when that party joins.
Okay. Okay. And then I think you had talked with someone else about the potential for exit costs to leave Markets Plus. So which I think we're kind of just talking about a situation where that might occur if you sign the Phase 2 funding agreement and then don't go forward with entry, or go forward with entry and then remove yourself. And what do you understand those exit fees would be based upon?
My understanding is the exit fee obligates you to pay off your Phase 2 financing. So if you're in Markets Plus and you stay in Markets Plus for 5 years, those first 5 years you've paid off your funding and you decide to leave then there's no additional exit fee.
Okay. So it's just about that original 150 million and the financing costs associated with that?
Yes.
Okay. Okay, let me get back to it. I skipped around a little because we just naturally went there. I wanted to ask a question about the wrap. So joining the wrap will have a one-time entry fee of $300,000. Is that accurate?
That's the estimate we have, yes.
And what do you understand that to cover?
It's kind of the same. Wrap's been information for a while, and Western Power Pool has first had a number of consultants working on wrap and has since hired staff. And the existing members of wrap would like the opportunity to not allow free riders, right? Folks coming in at the last minute and signing up for wrap and getting for free all of the services that wrap had developed over its previous years. So that's my understanding of what the 300,000 is supposed to cover.
So it's like repaying some approximation of the sunk cost of these other members?
Yes, well said.
Okay. And then additionally, there's a $750,000 annual cost of participation in wrap, right?
That's the estimate we got, yes.
And what do you understand that fee to cover different than the 300,000?
I think that it's the ongoing. So the wrap has, like I said, Western Power Pool manages the wrap, and there are several employees that are dedicated to the wrap program. So it's helping to pay their way. And also there is an administrator of the wrap. It also happens to be Southwest Power Pool. They have a staff over at SPP that does resource adequacy, all the calculations that go into the RA requirements for the RTO. And they farmed themselves out and signed a contract with Western Power Pool to provide those same services to wrap. So there's, their own Western Power Pool's own administrative costs and the costs of their contractors, they're FERC jurisdictional, so they make FERC filings, they have FERC lawyers, all of the costs associated with running that business.
Okay. And is that a negotiated fee, or that's just a fee that is what it is? That's what they told you, and that's the fee.
It's a formula based on, and I think partially it's based on how many total members there are, and then partially based on what the load is of each of the members. So it's like a Senate and House sort of membership.
Okay. And then I noticed in, we don't have to pull it up, but you'll probably recognize this to be the case. In Hearing Exhibit 102, Attachment MRG4, which is that 15-year estimated retail rate impact that we had looked at prior, the RAP administrative fee is modeled at that $700,000 and does not change through the 15-year projection. And I wonder what buttresses that assumption that this cost never goes up or down.
First, we didn't have anything to base it on, to base a change. And if RAP is growing, then, an assumption that their costs are going to increase, but since their participation increases, that the rates are staying flat. That's all it is based on an estimate and then growing membership.
Are there any historicals you're able to look at over the last several years to determine the trajectory?
I'm not aware of any. I haven't asked for any.
Okay. Are you aware how long the administrative fee has been $700,000?
No.
Okay. The company also anticipates internal expenditures of $13 to $15 million to align with SPP's Market Plus system. Is that accurate?
Yes.
What does that cost cover?
That is probably half of that is going to be a software package that's owned by a third party and has a licensing cost. And then the people and vendors and consultant time that is needed to implement that into the public service energy management system and our wholesale trading platform are all included in that estimate.
Okay, so this is like a $6 to $7 million a year software license.
Yeah, I think it's close to that. Expected to be close to that. I'll say that the company hasn't signed a contract with the primary vendor yet, and frankly, I'm not sure. I think the other Marcus Plus parties are still interviewing and evaluating proposals from their primary vendors. So that's why the number is still preliminary.
Okay. So with that software that would be integrated and any internal or external expertise to integrate it that's being bought for that $13 to $15 million a year, are any of those the same as would be required to join a full RTO, or are these all kind of bespoke to the Markets Plus concept?
A little of each, Commissioner. The main platforms are very similar, and in particular, if joining the SPP RTO versus joining the SPP Markets Plus, a lot of the same terms are used. So I think that some of the software would be transferable across the markets, but yet they're still two different markets. And the RTO market has a lot more functionality. It has financial transmission rights, and it has network load and all of those things that the RTO, being the transmission provider, has, and Markets Plus doesn't, because those aren't functions that SPP is going to perform in Markets Plus.
Okay. So it's not it sounds kind of uncertain if this is the same software. Maybe some components would be the same, but you might need other software if you went to a full RTO.
Yes, I mean, I'm not, certainly not an expert on the software of RTO markets, but just occurs to me that there's going to be some similarities, but some differences because they're two different markets.
And are those kind of entirely annual licensing costs, or are there upfront or one-time costs associated with the implementation of new IT software and solutions?
I'm not sure. I would speculate, if I'm allowed, I'm not supposed to speculate, that we have an upfront cost and then we have a licensing fee that's on an annual basis, similar to the models that we lease for, ERPs and things like that.
Okay. I was looking at attachment MRG4, which is the one you went through with Mr. Fanyo, doing the same kind of simple subtraction he was, right, between the revenue from retail and the adjusted revenue with the markets plus. And then went a step further and went with a cumulative costs and benefits below that. And would it sound right to you that the first time I got to a cumulative benefit was in the year 2040?
I would ask you to ask Mr. Bacher that question. We were talking across lunch and lamenting the fact that the MRG4 wasn't in a spreadsheet where we could highlight and do some summations like you did. So yeah, I'd ask you to ask him that question.
Okay, we do have an executable in the record, just as far as I understand. That's what I was using. All right. Also, maybe we'll just bring it up. It'll be a little easier. Sorry, Ms. Federico. Do you have MRG4 available?
I have it up. Did you want the executable version?
It actually doesn't matter for this question.
Perfect.
I just wanted to look down at line 18. You can zoom in as far as we don't need to see the whole. Focus on the left-hand side and just make it maybe. Yeah, there you go. Okay, so line 17 shows electric retail sales in gigawatt hours. And I was just wondering upon what forecast is that based?
I would ask you to ask Mr. Bacher. I assume it's from the same forecast that's referenced above in our JTS case.
Okay. Are you aware, and I can certainly move on to him as well, but if the retail sales go up or down, are you familiar with what would happen to the calculations here?
If the retail sales are higher than shown here, then the cost per kilowatt hour would be lower and vice versa.
And if the retail sales are lower than is shown here, the retail cost would go up?
Correct.
Retail rate, sorry.
Correct.
Okay. And are there fundamental impacts? I just wanted to ask this because, I mean, there's some simple math on this sheet or it really just divides. So like it's pretty easy to tell what happens if you change that number. But does the formula meaningfully change for any of your administrative fees if your retail sales are significantly different than shown here? Like that should also be accounted for in looking at that.
Our share of the total Marcus Plus administrative fees changes based on our load and the balance of the total Marcus Plus footprint load. So if the entire retail footprint of Marcus Plus went up 3% and Marcus Plus expenses went up 3%, then effectively the rate would be the same.
Okay. And when you say load, you're talking about capacity or sales?
Energy, because Marcus Plus admin fee admin fees are collected based on market transactions on an hourly basis.
Okay, so sales or energy. Okay. Let me see. If you end participation in Markets Plus at any time, I don't really know, first 5 years or not, would you have to leave RAP as well?
No, we would not, if we left Markets Plus, we would not have to still be in RAP, but we could remain in RAP.
Okay, you would have the choice
Correct.
to stay in or leave at that juncture.
Yes.
Is there any sort of cost to exit RAP?
I don't know the answer to that question. If there is, I'm sure it's fairly small.
Okay. Is there any mandatory timeline to notice an exit for RAP?
I'm sure there is, but I haven't seen the RAP contract.
Okay. And is there any required timeline of notice to exit Markets Plus?
There is some notice requirements in the phase 2 funding agreement. I'm not sure what they are right at the top of my head though.
Okay. So, and that would mean if you decide to leave, it could be, I don't know, I'm speculating, 12 months, 18 months, whatever might be in there, that you would still be required to pay your administrative costs and your normal costs as you go.
I would assume it would be consistent with the notice provision, yes.
Okay. I have a couple questions about voting. You indicated in your testimony, thank you, Ms. Federico, sorry, that the company must execute the phase 2 funding agreement by July 23rd, 2025 to be eligible to request voting seats in the working groups and task forces. Is that accurate?
Yes, it is.
I just had a question about the way that's written. Does requesting a voting seat mean you get a voting seat?
Essentially, it's kind of two pieces. So the company has seats on most of the working groups and task forces. If we sign the phase 2 funding agreement, we can keep all of those seats. Those are going to be transferred over. So if that same person, like I'm the rep on the transmission working group, and if I want to keep my seat, I just inform SPP I'm keeping my seat. If I wanted to replace myself with someone else from the company, then I would request that person be the replacement. Now, having seats on the committees today is part of the story, but frankly, a bigger part of the story is that these working groups and task forces, all except for the Markets Plus Executive Committee, because everybody who's a member of Markets Plus has a seat on the what we call the MPEC. But for working groups and task forces, the goal of each of those task forces and working groups is to have equivalent representation by each of the 3 sectors. So the investor-owned sector, the public power sector, and the independent sector. So as long as, typically when I think about it, going into phase 2, there's only Arizona Public Service, Tucson Electric, Puget Sound Energy that will be in the investor-owned utilities sector. So adding public service not only adds a rep in the IOU sector for all of these work groups and task forces, but also increases the size of the voting membership in each. So it's a benefit to the Markets Plus parties to have larger work groups with more representation across each of the sectors.
Okay. So under the presumption the market's designed to grow and add members over time, participants, I mean, they're not called members. How do later entrants gain any voting authority?
That's a good question. It would be like if public service doesn't sign on time, then we would have to, and I'm not sure exactly when or how often, but we would have to sign up as a member, and it is a member for those that are participating in the market, and then request that each of these specific work groups either increase their size to accommodate us, or only apply in work groups that have vacancies in our sector.
Do you think it would be a deterrent to future members if there is no way to meaningfully gain representation or voting rights in these groups?
I mean, it could. I mean, I've have some experience in the SPP RTO in the East, and voting seats are important. You know, when you have a work group that, you know, has 100 people that want to have a voting seat, but there's only, you know, 30 seats, you know, they're important to get and hold on to. And, you know, there's no guarantee that you know, for example, if you have a voting seat, this voting seats in the SPP markets are assigned to a person, not to a company. And so if that person who has your voting seat in an important committee, you know, retires or leaves the company, you can put in a replacement to get that voting seat, but you're not guaranteed that seat. Another company may put their name in and the person have better experience and end up losing a voting seat. So I think as the market progresses over the years, these voting seats are going to be potentially more important. But what I'll say is during the course of a meeting, any stakeholder can speak up, and many stakeholders do that don't have voting rights, and it's just as important, except for when it comes to the vote.
Okay, so does that work similar? I wasn't sure if you were using an SPP RTO example or saying that for Markets Plus, that's how to work, that these voting seats will be assigned to individuals rather than companies.
It's that way in the RTO, and it is also that way in Markets Plus.
Okay, so this kind of getting in by the deadline of July 23rd, 2005 works so long as it's the same human that has that voting seat.
Yeah, we're guaranteed if we're the same human.
But if it's a new human, you know, you retire, eventually you will, or whoever has this seat, getting in before July 23rd, 2025 may not mean anything at that point.
Correct. Yeah, I mean, there's yeah, then you have to expand the size of the group or hope that one of the three other IOUs person also retires. And your replacement is better suited and has better experience than theirs.
Like the Supreme Court, y'all are going for like younger people so they can keep their lifetime appointment there. Okay, just a couple other questions for you. So you've described, I think, I understand you've described a few of what I understand to be the company's perceived downsides of a potential full RTO in some of your previous responses. So that's not like really where I'm intending to go. But I wanted to take your temperature a little more and understand the company's intent as it is with regards to filing an application to join a full RTO before the statutory deadline for 2030. So can you tell me what the company's current intent is?
I can't tell you for sure. I mean, our plan today is to enter into this Markets Plus market, and we'll have a plan in place in that period of time to either request approval to join an RTO or to request a waiver. Maybe Marcus Plus is working out great, or to request a delay.
That's kind of why I'm asking. You don't normally hear those three options as described, with the statutory requirement as being somewhat equal chance. And I guess what I'm hearing sounds like that. So I just wanted to understand if there was an intent or a strategy on the part of the company. I mean, as I understand it, the requirement is in 4.5 years. It would take 18 months for you to submit. So within 3 years, the company would need to submit to join the market. Presumably, it would take years of discussions and negotiations to execute on that. It seems to me every market-related thing has taken years of discussions and negotiations. So I guess, are you currently talking to SPP West about joining a full RTO?
No, I'm not talking to SPP RTO West about joining the RTO. The functions that we describe about maintaining control are very important at this point in time, with load growth, with massive amounts of new generation that we need to meet our load and to meet our climate goals. And we don't think we can do it in an RTO environment. I think we feel like we have to be independent to be able to run those studies and those queues ourselves, and we're doing this in the best interest of the climate goals and our customers.
Okay, so given the company's, I guess, stance on the downsides of a full RTO, do you have any intention of talking to SPP West about joining a full RTO?
I think that one of the big problems in the RTO is the delays and the continual restudies in their interconnection process, both for load and generation. They have good plans to try to resolve those issues, and in the next 3 years, if those issues look like they're being resolved, and that could definitely change our interest in joining the RTO. And then, of course, if we file an application, it has different studies that we'll have to run, the comparative analyses and whatnot that will have to go along with that. I think
so can I summarize this, see if I heard you right? Unless you see movement on the interconnection issue improving significantly, my understanding is you have no intent to talk to SPP West about joining a full RTO.
I think that that interconnection process is so important that I don't think it would be in the best interest of our customers for us to jump that gun.
Okay, 2 more questions. You had described in one of your previous conversations as the benefits of joining RTO would have to be so great as to offset the costs you've already paid to participate in Markets Plus. So to me, we're kind of attributing this extra bar maybe for the full RTO, an additional burden of having to overcome the cost of this interim market. Is that how you see it? That's how I understood your comments.
Yeah, that is what I said, isn't it?
I guess just to put a finer point on that, I did out Mr. Fanio's math. I did the cumulative as I described to you. In 2031, the cumulative costs are $29 million. So if the company went to, now apply to join an RTO, that whole $29 million would kind of be seen as a cost to the RTO because we have to abandon Markets Plus. Is that the right interpretation?
I think it would definitely need to be incorporated into the conversation and into the analysis. I mean, those are costs that are sunk and should be part of the conversation at least.
Those are costs that are sunk if the company joins Market Plus.
Yes.
Okay. Those are my only questions. Thanks, Mr. Taylor.
Thank you.
Thanks, Commissioner Gilman. Commissioner Plant?
Thanks. Good afternoon, Mr. Taylor. I think, a lot of my questions have been answered, but I still have a few, and some may be slightly repetitive just because of some of the different aspects that I'm asking about. So I apologize for that in advance. So just for clarification, just in this hearing, I've heard SPP, RTO, RTO West, SPP West. We're talking about the same thing there, right? That's basically the RTO.
Yes.
By a bunch of different names. Okay. And you indicated earlier that Markets Plus is a step toward joining RTO West. I think you were talking about the WEIS is an incremental step, and Markets Plus is the next step, I think is what I heard you say in joining an organized market.
Correct. It's the next step in our evolution in compliance with Senate Bill 72.
And then as I think you were just discussing with Commissioner Gilman, and you talked about with Mr. Fanyo and Ms. Lowry, if the company were to join a statutory OWM, the cost with Markets Plus would need to be paid off, which would increase the cost of joining an OWM, and that would need to be offset by benefits. Is that the same with RTO West, or is that just with CAISO expansion? Is it the same cost is what I'm just wondering.
Yes, Commissioner, I believe it is, because if we were to join and then exit Markets Plus before the loan is paid off, for whatever reason, we would still need to pay off the loan.
I guess I was kind of curious about that because you talked about Markets Plus being a step towards the organized market, but then you're saying that all that collateral would basically be lost regardless of whichever market we join. Is that true?
We're required, the exit fee is paying off the loan.
Okay.
After the loan's paid off, there's no exit.
And that doesn't matter which market.
It doesn't matter where you go. Correct.
There's no crossover at all.
No, not that I know.
So should we think about Markets Plus as a step towards an organized wholesale market or as an alternative to an organized wholesale market? Or do we just not know?
I think it could be considered a step toward being an RTO member, but only to the extent, Commissioner, that the same speech I've made to a few folks already today and throughout my testimony, if that organized wholesale market can improve the things that I think it's lacking on right now, like generator connection, like transmission planning, like load expansions, I think that will go a long way toward a future application to join an OWM. But for the interest of all of the reasons I've said, to meet our clean energy goals and our customer goals, Markets Plus is the choice that we've made today, and it supports our need to continue to build our system out quickly.
And as I think you were talking about with Ms. Keene, it's possible that there are transmission costs associated with Markets Plus in terms of expanding your capacity to interconnect to the other Markets Plus participants. Would that be the same sort of interconnections that would be made in a RTO sort of environment, or would those be entirely separate or different?
They could be the same, they could be different. I mean, obviously if Markets Plus stays static forever and we built a line with our partners and it interconnected in Arizona, say, then that's a project that we and whoever we build that line with would separately go out and get, make applications to their respective commissions for cost recovery. Now, what if the RTO expands into the Markets Plus world? Then you've built a line that's connected Markets Plus, and it's also connected the OWM or the RTO itself, if the RTO absorbs Markets Plus. So it could be, it could provide, the benefits associated with just a Markets Plus to Markets Plus project, and increasing throughput and renewable integration, capacity sharing, all of those things. But it could also translate into, an RTO project, in the future as well.
So you're saying that until you know what the footprint of an RTL West is, you don't know if those costs would then transfer.
I think maybe a better way to say it is Markets Plus is built to expand beyond its current, half or 10 or 11 signatories. The RTO is also primed to expand. So either of those could occur, and then, Markets Plus expands, but then the RTO expands into Markets Plus, and that transmission you built just for transactions in Markets Plus have got a greater benefit, right? Because throughout the entire RTO footprint.
Okay, thanks. And in WGM4, the attachment that we were talking about just a minute ago, there are costs and benefits associated with the fuel that I think now has changed to, I don't know, is it production? I can't remember.
Yes.
Changed to. And with the revenue requirement on lines 3, 15, and 5. And are the fuel benefits essentially the same for Markets Plus and joining any other, a regional market, for example? Is it just basically the interconnection with other generation sources that leads to that fuel savings? Or is that, specifically a savings that's associated with Markets Plus? I mean, I think those numbers probably are the same, but should we expect the same in any kind of an integrated market?
Those numbers are specifically for participation in Markets Plus. They're not those numbers would be different if we were talking about the California EDAM or the SPP RTO. So no, they're specifically for the Markets Plus parties. And then of course we made adjustments based on transfer capability, move those numbers down because we're not directly, because the fact that many of our neighbors are joining the RTO. So we reduce the benefits down, but it is specifically a Markets Plus.
But we would expect some fuel saving, or basically these production savings, as long as you're integrating with other, somehow, if you're integrating with other generation that's across a broader area.
You'd think so, but in the WMEG study, there was a footprint study, was called the EDAM footprint, where it essentially put almost the entire West in the EDAM, and actually in that case, public services costs went up; they didn't go down.
Okay.
So it's not a definite answer on any market, produces savings.
Okay. Similarly, and you just mentioned this to Commissioner Gilman, you said that uh, uh, an RTO would impact your ability to meet your climate goals. I would just think that a larger geographic footprint would increase your ability to meet climate goals at a lower cost. I think that's what NREL's shown in their studies. Broad geographic diversity, increases the overall efficiency of renewables when they're spread across a larger load footprint. So wouldn't you see that benefit with a larger regional footprint, whether that's Markets Plus or an RTO, but just the integration of numerous clean energy resources across a larger geographic footprint should enable you to do that?
Yes, Commissioner. Generally speaking, yes, but the integration, west to east or north to south is based on transmission. Public service isn't well connected. We have these beautiful mountain ranges that preclude some of that. And so integration on an hourly basis between time zones and whatnot, we're limited on. And functionally, if you think about the system, and it's been a few years since I've been on that side of the company, but I think at the time I left 2 years ago, we had 12,000 megawatts of generation on our system. Maybe now we have 13 or 14,000 to serve 7,000 megawatts of load. And that's because most of that generation is renewable. So you're faced with curtailing that energy a lot of the time, or handing it off to your market partners. So it's a function of transmission interconnectivity and just the massive amount of renewables that we're putting on our system, and that amount of renewables addition is primarily what is helping us achieve our climate goals. It's primarily what are we putting in the ground to serve our own customers.
So you're saying really the barrier is getting east and getting west. So if you had more DC interties, for example, to get into the Eastern Connect, then that would help with that situation. Or if you were to connect to a high capacity line going west, that would address that situation. But if you're just looking at north and south, you don't get quite as much of the benefit. Is that
right? Adding new transmission to, I think there's north-south diversity as well. Don't get me wrong. But yeah, transmission definitely helps, right? You connect to a 3,000 megawatt line and you have access to all 3,000 megawatts. That's going to provide a lot of resource diversity.
Yeah. And one more follow-up from your discussion with Commissioner Gilman. You said that as new participants come in, each participant's share goes down, so the collateral would go down. And that would show up as a credit on the collateral, just basically reducing your time to pay off. Is that?
My understanding is the collateral itself, as new parties come in, each party's collateral, or each, folks that are already in. So if our collateral was $20 million and a relatively large company came in and it reduced our collateral to $18 million, then the next time we needed to renew our letter of credit, it would be for a lower amount, which is a lower cost.
Okay. And that happens on an annual basis or something? I would assume.
I'm not
Only
sure.
a 5-year payback, so
I'm not sure about terms of letters of credit. That's well outside of my expertise.
Understand. Let me see if I have any other questions in here. Okay, yeah, the PRM. You did talk with Ms. King about the planning reserve margin, and if I were to note that the 2021 ERP planning reserve margin was somewhere around 18%, I think, and the Markets Plus PRM or the RAP PRM is much lower than that. Should that impact our evaluation of the resources that we're considering are coming into the system in response to the 2021 ERP? I mean, if we're looking at a join date that's more or less concurrent with a lot of those resources coming on, should we be considering the joining of the Markets Plus as impacting that that requirement? Because we could get some of that PRM from the Markets Plus system, I would assume.
I would say no. The Markets Plus or the RAP program. Markets Plus isn't the resource adequacy program. That's the RAP program. Sorry, your screen froze. I just want to make sure. Okay, there you're back.
I'm sorry. I think that was me freezing, right?
Oh, yeah,
Since everybody else froze on my screen, I'm assuming that was me.
all right, threw me off there. No, so the RAP program calculates planning reserve margins in 2 separate seasons for, let's just say, a year out. And when we're in front of you in the resource planning paradigm, we're planning a much longer term. So the PRMs that are agreed upon by the commission and the long-term resource plan, I think, are the most valid, because the RAP developed PRMs could change every year, but they'll be a good tool to understand and help us buy if we're short. I mean, if we're short of RAP, we're short of this commission's requirements as well. So I hope that answered your question.
Should we expect that if we were to join Markets Plus, that the reserve margin requirements of future ERPs would likely be lower?
I think as the RAP requirements are better developed and the company and the commission work together on final reserve margins, I think the RAP program could result in lower requirements here in Colorado on a long-term basis. But that's I think that's what I think the main benefit in relation to the resource planning process is.
Okay. I think, Mr. Chairman, I believe that's all of my questions. Thanks.
Thank you, Commissioner Plant. Mr. Taylor, I want to start off talking about SEAMS issues. It's my understanding that there's 2 balancing authorities in Colorado, one run by WAPA and the other by a public service company. Is that right?
Yes, that's right.
And the numbers I have in my head are that the WAPA balancing authority might have a rough coincident peak demand to say 3,000 megawatts in Colorado. And I think you just said to Commissioner Plant that public service company is about 7,000 megawatts. Is that sort of the right order of magnitude?
Yes, I think that's close enough. Yes.
Okay. And my understanding is that both WAPA and Tri-State have additional load and generation in the eastern portion of SPP RTO. That's over and above the 3,000 megawatts that they have in the Colorado Balancing Authority. Is that factually accurate?
That is true.
Okay. And given that, my sense is that both WAPA and Tri-State are committed to join SPP RTO West. I assume to get one market operator and structure over as much of their collective generation and load as reasonably possible, because it's located in both the West and East. Is that generally consistent with your understanding of where WAPA and Tri-State are headed?
Yes, I'd agree with that.
Okay. And Mr. Dalkey says in his direct testimony, but in terms of interconnectivity, it seems like the strongest transmission in Colorado is within and between the Colorado balancing authorities. Is that right? And I think you spoke to this before. East and west, it's lower because of the asynchronous, the divide, the mountains, and limited transfer capability north and south. So is that a fair characterization of your testimony and your understanding?
Is your question, is our best interconnectivity between the two existing BAs in Colorado?
Yes, within and between them. That is the question.
It is. It is. That is the highest level.
All right. So I guess can we just talk about the seams between the two Colorado balancing authorities and Markets Plus and SPP RTO West? In your rebuttal testimony, you talk about the real-time dispatchable transaction tool and then some approaches used back east. I get that this is a work in progress and still evolving, but what would it take to get back to where we are now with Weiss and optimized dispatch over both balancing authorities? Is that 1 year out, 3 years out, 5 years out? And do these tools get us a third of the way there, halfway there, all the way there to Weiss? And look, I know it's a moving target, but just where are we at, and where we're going to with these tools?
Well, I'd say in the Weiss market, we cap out on being able to trade between BAs, probably in the 600 to 900 megawatt range. And the reason for that is that if we're pushing into the other BA and our wind drops, the other BA can't recover in time, and so we have an ACE problem between the two. So target for optimizing between RTO West and Piesco BA is probably in that range of 600 to 900 megawatts. So it's not a 5,000 megawatt solution. RTDTs, I think we could use and get some of that back, right? Some of that capability back, because it really is it is real time. We still have those limitations of what happens in the other BA when a purchase goes away and you have to recover from it. The other tools like full optimization between the RTO market and Markets Plus are, they're probably 3-5 years out. They are works in progress, and at the same time, there's also works in progress to optimize better between two markets that don't even exist yet, Markets Plus and EDAM. So they're all works in progress and are going to take some time. There's incremental things that we can put in, like RTDT, really soon, that are definitely the beginning to the optimization struggles.
And just so when you said 3 to 5 years out, were you talking about unit commitment being 3 to 5 years out and trying to optimize day ahead pricing, or were you still talking about real-time dispatch?
I was talking about market to market integration, market to market optimization, which would be day ahead and real time.
Okay, so it sounds like maybe we get the majority of the dispatch benefit through the real-time dispatchable tool, but the broader benefits, unit commitment and fully optimizing dispatch, are some years away. And do you think we get there in the coming years, or do we get to 100% of the way if we had one integrated day ahead market, or do we get to 70%, or it's just too soon to say?
Yeah, it's too soon to say with two or three different market operators. Could we get 100% of the way there with 2 or 3 different market operators running 2 or 3 different markets, no, we wouldn't get 100% of the way there. But I think that's the goal of this. This is such a big conversation. This whole SEAMS issue is such a big conversation throughout the West that the parties in the market and the market operators are all interested and want to get the issue off the ground and increase optimization.
Just one last question on this area. Your testimony hints at this, but any thoughts on what it would take to get to, call it markets plus, where you eliminated transmission pancaking and improved the reserve sharing again among the two BAs? That's 5 or 7 years, and I'm just trying to get to the end game, the timing, and what it takes and where it leaves us.
I think the key to adding functionality to Markets Plus, adding an ancillary services market, allowing or enabling VA consolidation, those are the things that are truly going to provide the reliability benefits, the ability to integrate, and that needs transmission. That needs more transmission than is in the ground now between the company and other Markets Plus parties, or even parties that are in Markets Plus. So it's how long does it take to build transmission, right? It's 5, 7, 10 years from true consolidation. But there's tools we're starting to look at, ADI, we're talking about RTDT, and we're getting there. We're moving down that road, but transmission is really the key to any new VA you want to interconnect to and really provide that reliability benefit.
And just focusing on the WAPA BA and the Public Service Company BA, do you think this Markets Plus approach and WAPA and RTO West helps us better integrate transmission planning between the two balancing authorities? Or do you think we're still on 2 separate tracks, even within Colorado?
The WAPA BA moving into the RTO gets a different paradigm. I expect SPP, SPP will be the transmission planner for that region because we're not integrating into that region. So we're not consolidating the transmission planning functions.
How important do you think it is to have a common operator over both the WAPA BA and the Public Service Company BA in terms of moving towards this future as compared to, having a CAISO SEAM, or as compared to Fiesco staying out of Markets Plus?
I think it is important. I addressed that a little bit in my rebuttal testimony, to have the same market operator. That market operator understands the similarities and differences between the 2 markets that it's operating, and it's hearing from both of its markets participants the need to integrate better with the other.
Yeah. I want to talk about how certain requirements that apply to public service might extend to other market participants, starting with GHG emissions tracking. If we could pull up Hearing Exhibit 101, attachment JCT4, and this is a letter signed by Public Service Company in Tri-State that was developed in consultation with the Air Pollution Control Division of CDPHE, the Colorado PUC, CEO, and other stakeholders. Do you recognize this letter, Mr. Taylor?
Yes, I do, sir.
And can we go to the bottom of page 1 and maybe the top of page 2? And do you see the resource mapping? where it says the expectation of both the utilities and the state regulators is that thermal units owned by Colorado utilities located in the transmission control constrained balancing authority will be mapped to the resource stack of the entity claiming capacity credit. Do you see that? Now, I get how that applies to Public Service Company and Tri-State as signatories, but do you have any sense of how this would apply to the market participants? Would it be through like the Air Pollution Control Division? Would SPP provide the data in these formats, or would Public Service Company, in the context of a balancing authority tariff that is yet to be filed, would you require it? Any thoughts on how this binds on all market participants beyond Tri-State and Public Service?
I believe it could be, it's a part of the development of the protocols through GHG that have been developed so far, as well as implementation through the Markets Plus program over the next 2 years before the program goes live. But I seem to recall that the attestation and requirements of each resource being mapped only to one entity as being part of that.
So an entity seeking to join, so any load in the Public Service Company balancing authority would have to attest that they will comply with this. Is that sort of the way it would work?
I'm not sure, Chairman. I would hope so.
In your statement of position, if you have any guidance on this, I'd greatly appreciate it. And I think at the top of page 3, there's a similar expectation. Maybe, yes, this approach reflects the expectations that the market participants are going to do it in accordance with this methodology. So again, if you can help us understand how this might apply to the market participants, that would be greatly appreciated. You can take this down, Ms. Federico. A similar question on resource adequacy. In Colorado, is it fair to say that this commission does not have any binding resource planning or RA jurisdiction over municipal utilities, distribution co-ops that have exited contracts with either Tri-State or Public Service Company, or over the power marketers? Is that sort of a factually accurate statement in your view?
Yes, in my view, it is accurate.
And does any other government entity have meaningful RA oversight over these entities under the status quo? Said another way, is there any current way to penalize utilities, power marketers, or other entities if they don't meet reasonable planning reserve margin requirements or otherwise lean on the balancing authority under emergency conditions?
No, my understanding is there's no such thing as a federal RA requirement.
But in response to your testimony in response to Ms. Keene, it sounds like PSCO will be obligated to comply with RAP as part of joining Markets Plus. Is it true that other loads in your balancing authority will also be required to comply with RAP? So would Public Service Company joining Markets Plus sort of create binding commitments on these other loads in your balancing authority?
I think we are leaning toward that direction, that if the BA, the balancing authority, is subject to the RAP requirements, then the load serving entities within the BA are subject to their share, or the amounts of resources and loads that they bring.
And how would that work mechanically? Would they have to attest that they're in compliance with RAP as part of being able to be a market participant? Do you know mechanically how that works?
I think separate submissions to RAP is one way. A second way is through their participation in our FERC open access tariff, which has balancing authority, sections, and actually the creation of an ancillary service or tariff requirement for resource adequacy is a related way for the company and the other utilities located in our BA to comply.
And to the extent entities are hundreds of megawatts short on their resource adequacy requirements under RAP, the benefits of resolving that could be in the tens of millions of dollars. Is that possible?
Yes, absolutely possible.
All right. Just a few more questions. As I understand it, customers and other stakeholders in Colorado do not currently have access to publicly available hourly wholesale market price data. Is that consistent with your understanding?
Customers in Colorado do not have access to?
Yeah.
I think we have access I just don't know if it's public access to market price data in the RTO and in WISE. But I'm not sure the extent of it or if it's public. I'm sorry.
All right. But in Markets Plus, would it be fair to say there would be publicly available real-time hourly market clearing price data?
Yeah.
And how would it be available? Would there be a website that people could log on to, sort of like SPP RTO East? Or do you have any thoughts on how we could make that available to customers?
I think, like I said, on the RTO side, and it's the same market operator, I imagine the same massive amount of data is available to those who know where to find it.
All right. It seems like there's lots of work in front of us and considerable uncertainty. In the event that this commission does approve this application, any thoughts if we ask the company to provide periodic reports, perhaps in a non-litigated process that still allows input from the stakeholders, that provides updates on the costs, seams issues, and sort of the evolving understanding of these reliability, GHG tracking, market costs and benefits?
I'd say, definitely. I think, the company provides a lot of reports to the commission. We provide reports in the WISE process and have for the past couple of years. I'd also say maybe that's a question you may want to ask Mr. Burman, who has a lot more experience in the creation and the submittals that the company makes to the commission.
All right. Thank you, Mr. Taylor. Mr. Denman, I'm thinking maybe we take a 15-minute break till 3:10 and then keep going with your redirect.
Yes, sir. That's fine. Thank you.
All right. Let's come back at 3:10. Thanks all. Mr. Nemman.
Mr. Taylor, you might want to turn your microphone on.
You might turn your camera so you're more centered. Half your face is in your label. Can you move your camera?
On my screen, it looks like it, but
Oh no, I was talking to Mr. Taylor.
oh, my apologies, Your Honor. I don't know if he's got an adjustable camera or not.
All right, just keep going.
Yeah, these cameras don't move up and down very well.
All right.
Well, I have one of the newer ones. As long as the commissioners and Harriet can hear him, that's.
I would love it if you guys put headphones in that on the, but whatever.
Well, thank you, Your Honor. I do have some redirect from Mr. Taylor. I'm going to ask you to try to remember some of the cross-examination from earlier today, Mr. Taylor. When you were visiting with Ms. Keene, she asked you a few questions about compliance with the requirements of Senate Bill 21-072. Do you recall that discussion?
Yes, I recall.
Okay, and one of the questions had to do with whether or not Markets Plus is a reasonable effort to comply with the requirements of Senate Bill 21-072. Can you explain why joining Markets Plus is a reasonable effort to comply with those requirements?
Certainly, Markets Plus is a market that public service company, along with dozens of other utilities, help to create. It satisfies the requirements in the OWM rules of a day-ahead market, and importantly, it does not require the company to relinquish control of its transmission planning, its generator interconnection, and other functions that are so critical now as we're continuing our evolution to reduce carbon and add resources to meet our growing loads.
Okay. During your colloquy with Ms. Keene, there were a number of questions relating to Markets Plus and transmission about possibilities. For example, she asked, is it possible for this or is it possible for that? Do things change in the future during the time public service might be in Markets Plus if approved by the commission?
Oh, absolutely. Plans that are developed today will need to be changed, right, to reflect new additions and resources, new transmission between parties, all kinds of things. Just the way the market dispatches our system may result in some new ideas for beneficial transmission to help improve our part in the market.
So when you answered those questions, were you answering based on what you know today?
Well, certainly, yes.
And how difficult is it to speculate about future transmission planning given the changes that you just discussed?
It's difficult. It's why transmission planning is such a hard job and gets so much attention.
Okay. There were some questions about the E3 study and whether or not additional study of various things should be done, or whether public service company did study of certain things. Do you recall that line?
I do.
In your opinion, or strike that, do you have an opinion on whether the E3 study is adequate for purposes of this proceeding?
Yes, I believe the E3 study is adequate. It was an effort that involved 25 different utilities, putting all of our production and generation and transmission information into the E3 database. E3 performed a number of analyses with different footprints, different time horizons, different options. And then we adjusted their base results based on expectations or actual loss of interconnection capability, with our neighbors announcing that they were moving into the RTO. I think those adjustments, first down to 900 megawatts to represent that business as usual case, and what we were seeing real time in Weiss was a valuable adjustment. And then ultimately reducing that even more to reflect those parties' entry into the RTO, and then adjusting those benefits results down, I think was reasonable and satisfies, I think, the portion of the OWM rules that apply to that.
Okay. I want to ask you a couple of questions that came up during WRA's cross-examination. Do you remember a discussion about the WFA report and a 47% reduction to the GHG or greenhouse gas values? Do you remember that?
Yes.
Okay, thank you. Can you explain why that adjustment was a reasonable one to make?
I think it's reasonable for the same reason that we adjusted our export capability down in the cost benefit analysis. The WFA report shows that the trajectory of GHG reductions is proportionally greater in a market than out of a market, and to reflect the lower amount of interconnection we have with other Markets Plus participants. I think that adjustment down, that 47% adjustment to the GHG results is also reasonable.
Thank you. Council for WRA discussed with you transfers outside of the balancing authority, and discussed with you whether or not a study for import-export capability might have been made. Do you have an opinion on whether or not a specific study for import-export capability outside of the BA was needed?
No, I don't think it was needed. The WEMEG study, as we adjusted it in App 4, and then further adjusted it in this application, I think it was it in part is, the WEMEG study is an import-export study because it incorporates the capabilities of the BAs to transfer energy inside their BAs, as well as to transfer energy between the BAs. And we accurately did that in our work around that WMEG study.
Thank you. During your discussions with Ms. King and Mr. Fanyo, some discussion was had regarding whether market transactions are benefits, and whether there may be other benefits from joining Markets Plus. Do you recall that discussion?
Yes.
Can you explain, please, why market transactions are benefits of joining Markets Plus?
All market transactions, whether it's to serve your own load with your own generation, whether it's purchasing an incremental amount because the market was cheaper than your incremental unit, or whether you're incremental unit was cheaper than the market and you're selling excess energy into the market, all of those transactions and all of those costs are occurring, on a day ahead and hourly basis. And so putting them into the ECA, along with their associated costs on the market admin side, lines up the benefits that the company and its customers are going to see in the market with how the costs are incurred.
Are there other benefits that you wanted to talk with Mr. Fanyo about that you didn't get a chance for joining Markets Plus?
Yeah, production cost study identifies, those areas that it covers. Markets Plus has 2 stages of must offer, where the market participants have to offer enough generation in to serve their expected load, both on a day ahead and a real-time basis. I think that's a benefit that doesn't get picked up. I talked earlier about the reliability unit commitment process. When multiple parties have similar units that are capable of commit, and the cheapest one will be selected. That's a benefit. A third one is the market operator, while it's not the transmission service provider, it has the full transmission network model in its market engine, and it can see, real time what's happening on the transmission system as, maybe transmission element gets knocked out for whatever reason, or a generator gets knocked out, and it can adjust the market dispatch accordingly and do so and redispatch the market up to the limits of the transmission system, which is a higher level than a single BA operating by itself can do. It's has a much better view and be able to actually redispatch units, not only of one company, but everybody else in the market, to help get that optimal result.
I'm sorry that you trailed off. What was the last thing you said?
To get that optimal result.
Oh, thank you. Commissioner Gilman asked you a question about the phase 2 funding agreement, particularly regarding what's the exit notice requirement. Are you willing to look that up and report back to the commission tomorrow if you can, or during the hearing, on what the answer to that question is?
Certainly, yes, I'll do that.
Okay, and Commissioner Gilman will get that information for you. And finally, Chairman Blank asked about the availability of market price data. Do you have an opinion on whether market price data would be publicly available under Markets Plus?
Yes. What I found out, Chairman, after you asked that question, is that LMP data is widely available in the SPP RTO. It's available in the WISE market, and it will be available in Markets Plus. There's a number of databases and files that are accessible to the public, and I wasn't aware that they were fully as accessible as they are.
Okay, thank you. Mr. Chairman, that completes my redirect.
Thank you, Mr. Demon. Thank you, Mr. Taylor. Is Mr. Bacher there?
I need to make sure he is up. There he is. Mr. Bacher has turned his camera on, and he appears to be ready to rock and roll.
Mr. Bacher, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down. Is anybody with you or communicating with you in any way?
No.
That changes. Will you let us know?
Yes.
With that, back to you, Mr. Dunman.
Thank you. Mr. Bacher, please state your name and business address for the record.
William Bacher, and that's Bacher,
And the business address is 3500 Blake Street, Denver, Colorado.
What is your title?
Pricing consultant for Public Service Company of Colorado.
And are you employed by a public service company?
Yes.
Now, you're adopting the direct testimony filed by Mr. Grubert, which is hearing exhibit 103, I believe. And his attachments, you're also adopting, or I'm sorry, you've also filed in this case rebuttal testimony, and I don't have that in front of me. Is that hearing exhibit 105? So
it's 104.
104, thank you. I have a binder with a bunch of stuff in it, and I didn't get Mr. Bacher's out. So, Mr. Bacher, have you become familiar with Mr. Grubert's direct testimony and exhibits?
Yes.
Okay, and you're prepared to adopt those here today in testimony?
Yes.
Okay, and if I were to ask you the same questions in hearing exhibit 102 and hearing exhibit 104 today under oath, would your answers be the same?
Yes.
Okay, thank you. And Your Honor, I will tender Mr. Bacher for cross-examination.
Ms. Keen, I have 10 minutes.
Thank you very much. Chair Blank, I prepared for illustrative purposes only a version of hearing exhibit 102 attachment MRG4 that has some additional calculations on it. With your permission, I would bring that up to reduce the amount of mental math I asked Mr. Bacher to do.
That sounds good, and we'll just go through it and see if Mr. Denman has concerns.
Thank you, and I do have it marked as a hearing exhibit if anyone would like that instead. So if Ms. Federico could pull that up, it's marked as the illustrative exhibit. Great, thank you. Would you mind zooming up a little bit? Thanks so much.
Yeah, as long as, ma'am, as long as it's blown up enough so that the witness and I and everyone else can see it. Thank you, Ms. Federico.
Yeah, absolutely. And if you need that scaled differently, please just speak up. Mr. Bacher, do you recognize this document or the base of this document as the 15-year estimated retail rate impact analysis of joining Markets Plus?
Yes.
And subject to check, would you agree that the only difference between the original version of attachment NGR4, revision 1, and this illustrative version is the addition of what is shown in yellow highlights as row number 16A and 16B?
Yes.
And were you able to watch the discussion that Mr. Fanyo and Commissioner Gilman each had with your colleague, Mr. Taylor, this morning regarding this chart?
Yes.
And did any of Mr. Taylor's responses to questions, sorry, let me rephrase, do you agree with all of Mr. Taylor's responses to the questions related to this chart?
Yes.
Okay, great. That will help skip a few questions. And so would you agree that comparing the numbers in line 3, which is labeled the revenue from retail, with line 15, labeled the adjusted revenue with SCP Markets Plus, by comparing those two, we can extract the difference in annual revenue requirements between joining Markets Plus and not joining?
Correct. And that should be equal to lines, the sum of lines 5 through 13.
Great, thank you. And what is added here is line 16A is that calculation, the subtraction between those two lines. Subject to check, does that make sense to you?
Yes.
Great. And so the value, when the values in line 16A are negative for the years 2025 through 2031, that indicates that the revenue requirement for joining Markets Plus is higher than without joining, correct?
Correct.
And so if we add up each year's annual difference in the revenue requirement to the previous year's values, we would get a cumulative cost comparison between joining and not joining, and that's reflected in 16. Does that make sense to you?
Yes.
Great. And then subject to check, do these cumulative numbers that are included in line 16B book rate.
Yes.
Great, thank you. And so this shows a cumulative additional revenue requirement through the year 2031 of about $29.49 million. Does that seem right to you?
Yes.
And so by the end of 2031, public services customers will have cumulatively paid about $29 million more than if you had not joined Markets Plus based on this. Is that right?
Correct.
And so starting in 2032, this chart shows that the annual revenue requirement is less than not joining. That's when it starts to flip. Is that correct?
Yes.
And so it's not until that year that the cumulative cost will start to decrease.
Correct.
Okay. And then if we jump to year 2038, all the way through that year, there's a net cumulative cost to customers of joining Markets Plus, correct?
Correct.
And so it's not until more than 14 years from now that the customers will cumulatively have a benefit in the year 2039.
Correct. Based on these estimates, that is true.
That's all I have. Thank you very much.
And counsel, do I understand you're not moving that document?
I don't feel the need to, as I believe that the numbers can be just derived from what is already in the record, but if you or the commission would prefer that that be moved into the record, I'm happy to do so.
No, I would actually like a copy of it since I'd never seen it before you threw it up on the screen.
Yeah, absolutely. Yeah, happy to distribute that to other counsel in this proceeding unless anyone would prefer it be moved in the record.
And Your Honor, if I might, I'd like to have that marked as an exhibit. I think it would be helpful for the record if it was in there as an exhibit.
Absolutely. In which case,
yeah, somebody moving it.
I would request to move that exhibit as here in Exhibit 902.
I haven't had an opportunity to study whether or not any of those calculations are correct, and I think, Your Honor, I don't have an objection at at this point in time. I understand what the purpose of it was, but I'd like a chance to reserve the right to object if for some reason we determine that there's a bust in the calculations.
Yeah, let's hold off on this. If we could take this up first thing tomorrow once Mr. Denman's had a chance to look at it, and maybe you could renew your motion at that time.
I'll distribute to counsel momentarily.
That'd be great. Thank you, counsel. And thank you, Your Honor.
Thank you. WRA, Mr. Barrasso, I have 30 minutes.
Thank you, Mr. Chair. WRA will be waiving our cross with this witness.
All right. CEO, I have 15 minutes.
Hi, good afternoon, Mr. Bacher.
Good afternoon.
Nice to meet you. My name is Jessica Lowry and I represent the Colorado Energy Office. I just have one question for you. I want to point you to your rebuttal testimony, hearing Exhibit 104, page 7. Line 14. Actually, beginning on line 13. It says, the benefits of participating in Markets Plus would be realized through the ECA through the potential for lower energy costs. So including these costs properly aligns with the costs and benefits. Did I read that correctly?
Yes.
Okay. And as we've discussed throughout this hearing so far, there's no customer savings or net benefits through at least 2032, maybe even beyond to 2038, as we just saw in that exhibit, right?
Right.
Okay. So how does recovering the phase 2 costs of $18 to $20 million now or over the next 5 years through the ECA align with benefits to customers that you're claiming in your testimony if there are no benefits to customers for the first 5 to 7 years?
I think the UCA in their argument was including both the sales revenues from Markets Plus sales by the company, as well as any production cost benefits in the ECA, but was suggesting to exclude all admin fees and other costs that are on MRG I think 4 that we were just looking at. So the proposal was to include all benefits of market participation in the ECA, but none of the administrative costs or IT and software costs. So if you removed those costs, there would be a net benefit in the ECA.
Mhm. So are you agreeing with UCA's proposal?
No.
Why not?
The company views it as appropriate to include all benefits and costs in the ECA so that they're taken as a whole instead of, right? So the same ratepayer is paying this or receiving both the benefits and paying the costs of Markets Plus participation.
I guess what I'm trying to ask is what benefits would be flowing through the ECA if we've just seen that there aren't any benefits?
Well, I think there's both benefits and costs, right? This is taking a gross benefit and a gross cost, not the net benefit.
Okay,
Net
thank you.
cost.
That's all I have. Thank you, Mr. Bacher.
Thank you, Ms. Lowry. Climax, Mr. Fanyo.
Thank you, Mr. Bacher. My name is Richard Fanyo. I represent Climax Molybdenum Company. Ms. Federico, if you could call up MRG 4, the cost benefit spreadsheet. And this is not the illustrative one. It's the one that's in the record.
Yes, I've got that one up.
Okay, thank you. My first question, Ms. Bacher, is on line 14, or I'm sorry, 21, the delta. And that shows, well, first, I had this discussion earlier, but is that delta in units of dollars per kilowatt hour?
Yes.
Okay, and so when we look at 2026, it's $0.0001 per kilowatt hour, or 1/100th of a cent. Is that right?
Correct.
Okay. And the same would be true for each of the other numbers in that that line 21, right?
Correct.
Okay. Now, I am not clear whether that is the rate impact across all of public services customers, retail and wholesale, and retail all classes, or if it's some subset such as residentials. Could you explain that?
That is the impact across all retail, all classes of customers. Retail only, though, not wholesale.
Retail only. Okay. Now, so it combines residential, commercial, and industrial customers, special contract, all retail customers, right?
Correct.
So there's no breakout between those customer classes.
Correct.
Okay. So we don't know exactly what the impact would be on residentials or any of the other classes, but the aggregate among all classes would be what's shown on line 21, right?
Right.
Okay, let's assume that what's shown there is 1/100th of a cent per kilowatt hour is the retail impact on residential customers. If you would, Ms. make that assumption with me. And let's also assume a retail customer that uses 1,000 kilowatt hours per month. Would the impact on, or what would the 0.0001 cents per kilowatt hour be on that customer 1,000 kilowatt hours per month customer's bill?
I don't have a calculator in front of me, but in my head, I'm coming up with around 10 cents.
Very good. I would agree with that. So, and as we go across, we have a lot of, for that hypothetical, a lot of numbers in the same range, a couple of 20 cents, and then we get to savings of 10 cents a month. What is your sense of the customer's perception of what benefit that 10 or 20 cent increase or decrease in its bill would have? The customer's perception.
I don't think customers would notice much of a difference on their monthly bill.
Okay. Okay. Now, if we, I apologize because the way my screen is set up, it obscures the last few columns of the exhibit that is called up, but I think I could do this without correcting that. I think from the illustrative exhibit that was just shown with exhibits line 16A and 16B that Ms. Keene called up and is being reviewed, it's clear that by 2032, the costs are greater to customers, to retail customers, than they would be without Markets Plus. Do you agree with that?
Correct.
And it's only after 2032 that the lower costs start kicking in and the net finally appears to go in favor of customers somewhere around 2038. You understand, or agree with that?
I do.
Okay. So in light of that, does that mean that, well, in light of that, does that mean that if public service files an application to join an RTO or ISO by 2030, and therefore somehow melds Markets Plus into that or drops out of Markets Plus in place of, and instead of the new RTO, that the only effect of on customers would be an increased cost over the years up to 2030 with none of the benefits later on down the road.
So your question's around if the company spends the money to fund phase 2 funding IT software for Markets Plus and then moves to another market by 2030?
No, it moves into the market as you have proposed, would go live in October of 27.
Sorry, a market other than Markets Plus by 2030? Is that your?
Oh, yes. An OWM by 2030 is Senate Bill 072 conditionally requires.
Okay. I think Mr. Taylor addressed this, where if we were to move to a different market by 2030, that the benefits of that market would have to exceed the sunk costs of Markets Plus.
And would that include the extra costs that are incurred up through 2030?
I don't have the answer to that.
I'm wondering how the extra costs that customers would be paying through, I guess it would be 2029, would be recovered, or if they're just the customers have to absorb those costs when the new market replaces Markets Plus. Is that the plan or the effect?
I'm not really sure on the answer to that question. I think this analysis only looked at Markets Plus for the entire 17-year period. It did not consider moving to a different market within that 17-year period. So I don't know how the company would handle those costs.
Is it possible that the company could be a member of both Markets Plus ongoing after 2030, as well as join a OWM in 2030?
I'm not sure if that's a possibility.
Okay, so is it fair to conclude then from your testimony here that you don't know how the extra costs that customers would incur through at least 2030 would be reimbursed or not if the company joined an OWM in 2030? You don't know. Is that right?
Correct. As of today, the only plan is to request to join Markets Plus.
I understand the plan. I'm asking if you don't know what would happen to the extra costs that customers incurred and paid up to that point in 2030.
Your Honor, object, asked and answered. I mean, this is the third time Mr. Fanio's asked the same question, basically.
It's been asked, but not answered.
It's because he said he didn't know, and he said that it wasn't likely a possibility. So, Your Honor, I don't know how many times Mr. Fanio needs to ask the same question to get the same answer.
I'd like to hear that answer from him if I could.
All right. One more time, Mr. Bacher.
Yes, I don't know how the costs incurred in Markets Plus would be treated if PSCO or Public Service were to join another market in the future.
Okay. The other question is, you probably recall Mr. Taylor talking about the net benefit over the 15 years of 17.8 million. Do you recall that?
Yes.
Can we tell, or can you tell us how that number was calculated from the information on MRG4?
Yes, it's the sum of lines 5 through 13 from 2025 through 2042. So all of the gray shaded cells.
Okay, so line 5 is a production cost savings. That's a negative number throughout, starting in 27 on through 2042. The lines 6 through 13 are positive numbers, meaning extra costs, again, as they're incurred in those years. And so the cumulative total of line 5 over those 15 years, less the cumulative total of 6 through 13, ends up as 17.8. Is that right?
I believe using the signage in this exhibit, it would be negative 17.8, representing 17.8 million cost savings.
Okay. So that's a nominal number. It's not a net present value, right?
Correct. It is not a net present value.
Okay, which also confirms that the reduced costs don't start for customers until 2033 or 34, right?
Correct. I'd have to see the exhibit again, but it was in that time range.
Okay, that's all I have. Thank you, Mr. Bacher.
Thank you, Mr. Fanio. Ms. King.
CEC is not going to ask any questions of this witness. They've all been covered. Thank you.
Thank you. UCA.
UCA will also waive its cross-examination of Mr. Bacher. Thank you.
Staff.
Thank you, Mr. Oh,
I was just going to
apologies.
say the cross will be handled by my co-counsel, Justin Larson, Mr. Chairman.
All right, thank you.
Thanks, Mr. Chair. Just a few very brief questions for you, Mr. Bacher. And by the way, I'm Justin Larson. I represent trial staff. I don't believe we've met yet. So, Mr. Bacher, you were present today during Mr. Taylor's testimony, correct?
Right.
And did you hear Mr. Taylor say that the IT costs that you discussed in your rebuttal testimony were for licensing software from a third party?
That is part of those costs.
Given that testimony, would you agree that it's more like the company is renting this equipment rather than buying it?
I don't think you ever fully own software. I think the company would own the instance of software and the data included in the software that is proprietary to the company.
But the company nevertheless classifies these costs as capital expenditures, correct?
The project to implement and first start the project is considered capital, yes.
And you also stated it earlier in your discussion with, I believe it was with WRA's counsel, that removing the IT cost results in a net benefit. Do I have that right?
It results in a net benefit in the ECA, not overall, if those costs were to be included in a different rate mechanism.
So, but just including the IT costs removes the quote unquote net benefit until at least 2038. Do I have that right?
Correct.
Okay. No further questions from staff, Mr. Chair. Thank you.
Thank you. I don't think Commission Counsel had anything. So Commissioner Gilman.
Hi, good afternoon, Mr. Bacher.
Good afternoon.
Just a few questions from me. Maybe Ms. Federico, if we can pull back up the MRG4. It doesn't have to be executable, whatever's easiest for you. Thanks. Looking at line 17 there, where did the electric retail sales figures used here come from?
I'm fairly certain that the electric retail sales on line 17 also came from the 2024 JTS, same as the revenue from retail.
Okay, and I did find them there in an exhibit, but without a reference as to which forecast those are. Are those related to the base forecast, the low forecast, or some other forecast?
I'm not sure on which of the JTS forecasts they're based on.
Okay, but you didn't do different versions based on the different forecasts presented in JTS?
No.
Okay. 1 second, back to my page. And if those sales numbers end up being lower in reality than what's shown here, would that, my understanding for the years where there's a net cost to joining the market, that would just spread that cost over fewer sales and result in probably higher cost per kilowatt hour. Is that accurate?
Correct.
Okay. I talked with Mr. Taylor about all the various buckets of costs associated with Markets Plus. And the company anticipates internal expenditures of $13 to $15 million to align with the SPP Markets Plus system. Do you recall that?
Yes.
Okay. So looking here, would that be line 13?
Correct. That the line 13 represents the annual revenue requirement for those costs.
Okay, got it. And is the assumption those are all treated as capital costs?
I think for the capital portion of the project, I don't think ongoing O&M is treated as a capital cost.
Is a software license a capital cost?
I'm not 100% sure. I think the ongoing licensing fees are not, but that the initial, what the software that you're initially purchasing, there is a capital cost in that.
Okay. So I added up the figures that we're looking at here, and they add to $16.5 million through 2033, but the expenses stop in 2033. Can you explain to me why the expenses stop after 2033?
For this analysis, there was a useful life of 7 years placed on that capital asset.
Okay, so the assumption is that whatever that IT solution is that was being used and the consultants supporting it and the things Mr. Taylor described, that those have run the course of their life in that 7 years.
Correct. They would be fully depreciated at that point.
Okay. Is there a software or something needed to replace that and serve the same function that costs some money?
I don't think it would necessarily require a replacement at that time.
Okay, so is the assumption the company is making that all of those capabilities would be integrated into its own systems with no additional costs for IT after that point?
Not that there would not be additional IT costs for that to run that software, but that the capital portion of it would have been fully depreciated based on its useful life.
Okay, so there's a likely O&M expense for software that's not represented here that would be needed to enable continued participation in Markets Plus?
Correct.
Is there any estimation as to the cost of that on an annual basis?
There isn't. I think you would have to have a software vendor selected to have a better idea of what those costs would be.
But they're not zero.
Correct.
But they're generally represented in this model as zero.
Correct.
Okay. Okay. I think those are my only questions. Thank you.
Commissioner Plant.
Thank you. So I just have one quick question, and it relates to the same worksheet that you were just discussing with Commissioner Gilman, MRG-4. Looking at line 17 that Commissioner Gilman was referring to, subject to check, I guess, would you accept that in 2026, the increase in electric retail sales over the previous year is 4%? And
without a calculator, I'm not sure.
well, let me run through a few numbers and then you can just sort of tell me if it sounds right or not. And in 2027, it would be 7%. In 2028, it would be 12%. In 2029, 14%. And in 2030, 13%. Do those numbers seem about right to you in terms of annual increase in electric retail sales according to the numbers that are appearing there?
Yeah, I mean, according to the numbers in this exhibit, that seems correct. I think those numbers were developed as part of the JTS filing, not exclusively for this filing.
And then the projection, once it gets out to 2033, it drops back down to 4, 3, and then eventually to an annual growth rate of 2%. That seem right to you?
Yeah, that looks correct.
And the cost per kilowatt hour calculation there, the cost per kilowatt hour on line 18, that's just dividing basically the sales by the revenue. Is that correct?
18 is dividing line 3 by line 17.
Okay.
And line 20 is line 15 divided by line 17.
It'd be, okay, I gotcha. The adjusted revenue, basically.
Yep.
Okay. Great, thank you. I have no further questions.
Thanks, Commissioner Plant. You can actually leave that up. I just had a couple questions along the similar lines. So again, it sounds like the company expects that the total IT costs will be approximately 13 to 15 million. And based on that, it sounds like the company estimates that the IT cost annual retail revenue requirement would be between 2 and 3 million, as shown on line 13. It sounds like you've already testified that that's the case.
Correct, yes.
And so again, that level of revenue requirement would imply that you're amortizing the investment over 7 years with a WACC return. Is that correct? And I guess just instead of amortizing the investment and having the company earn a return, any thoughts if we just expense these costs in the ECA as they were actually incurred, given the overall economics of all this? Would a straight pass through better align the utilities incentives and be more appropriate here?
I think I would have to defer that question to Mr. Burman.
All right. That's all I had. Mr. Denman, redirect.
I only have one. Mr. Bachman, Commissioner Gilman asked you about some retail sales numbers that appear in hearing exhibit 102 attachment MRG-4 revised. And she asked you which forecast that those numbers might have come from in another docket. Can you find out that information and then report it back to the commission tomorrow, if possible?
Yes.
Okay, thank you. That's all I had, Your Honor.
Thank you, Mr. Bacher. Mr. Burman, you out there?
I am here.
You hold up your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
Yes, I will.
Back to you, Mr. Denman.
Thank you. Mr. Burman, please state your name and business address for the record.
My name is Stephen Burman, and that's spelled STEVENBERMAN. And business address is 3500 Blake Street.
And by whom are you employed and what is your position?
I am employed by Public Service Company of Colorado as a Regional Vice President of Regulatory and Pricing.
And did you file direct testimony in this case?
No, I filed only rebuttal testimony.
And in the course of preparing your rebuttal, did you review the answer testimony to which you respond in rebuttal?
I did.
And are you familiar with hearing exhibit 105 and attachment SPB-1, your rebuttal testimony?
I am.
Well, that's already been admitted into evidence. If I were to ask you the questions in hearing exhibit 105 today under oath, would your answers be the same?
They would.
Thank you, Mr. Burman. Mr. Burman's available for cross-examination, Mr. Chairman.
Thank you, AEU, Ms. Keene.
Hi, Mr. Burman. Good afternoon.
Good afternoon.
Nice to meet you. I'm Sarah Keene on behalf of Advanced Energy United. Ms. Federico, if you could please open hearing exhibit 105, Mr. Burman's rebuttal testimony. If we could go to page 8. Thank you very much. Starting on line 12, Mr. Burman, you state that if the commission determines in the future that remaining in the market is no longer in the public interest, that the company can exit. Did I get that right?
That's correct.
Thank you. And now I understand that you raised concerns with trial staff's proposal for a provisional revocation of the public interest standard, and that's the context of this. And I'm not asking you questions about your response to staff to be clear. Here, when you say that the company can exit Markets Plus based on a future commission determination that it's no longer in the public interest, how do you imagine that exit would happen? Like, what would be the process to effectuate such an exit?
So I think Mr. Taylor spoke to that the company is capable of exiting under the terms of our agreement to enter into the market. So I'm not sure exactly what that process is, but this is more to discuss that there should be a process whereby the commission and the company has an opportunity to participate to determine that the public interest is no longer being satisfied. And if that occurred and the commission made that determination, then the company could exit the market in the future. I think that's within our rights under the terms of entry.
Oh, thank you, and that's helpful. Can you just elaborate a little more so that the company and the commission should be able to sort of, I don't remember exactly, we said that work out together, both participate in that process. Can you just elaborate on what that might look like?
Yeah, well, I don't know that there's a concrete proposal for what that looks like. I think as I responded to staff, the concern was that if there were certain triggers, the commission could come to the decision to revoke that public interest standard provisionally or quickly without a process. And so the company would seek, like we would for anything else, that if there was a reason to review that and the commission felt that there may be a reason to revoke the public interest standard, then the company certainly would want an opportunity to respond and provide our side of whether we agree or disagree with that and have a process by which to conduct that, which assuming other parties would also be able to be a part of. Whether that could occur through or be initiated through the annual reporting, if there was something there to suggest that things had changed materially and we weren't seeing what we expected in the market. I think the other place where that could naturally happen is in the ECA prudence review, because again, companies proposing to recover the costs through the ECA, and all of the ECA costs are subject to an annual prudence review. So I think there's a couple options for how that could get initiated and ultimately proceed. But I wouldn't say that the company or any party has proposed a concrete process.
Thank you. Do you expect that any federal approvals would be necessary if you propose to exit Markets Plus after you had joined it?
I'm not sure. That would probably be a better question for Mr. Taylor. I'm not familiar enough with the terms of entry to know what applies there.
Okay, no problem. Thank you. If the commission wanted to order the company to withdraw from Markets Plus or otherwise just rescinded the public interest determination, do you have a rough sense of how long that process would take to effectuate a withdrawal?
No, well, I would just say typically the process for the ECA prudence review is like many processes in front of the commission. It takes several months. Typically, we're talking 6 to 9 month processes for applications or prudence review type activities. And certainly the commission has the authority to shorten those processes, as we've done here in this proceeding, to get to a decision more rapidly. So there is some discretion there, but I don't think it would be immediate.
And so you both have the several months of a ECA prudence review or some other proceeding in front of the commission. And then do you think there would be additional time after the commission makes its determination for public service to take additional steps with SCP in order to withdraw from Markets Plus?
I don't know what the timeline is. Like how much notice, or if the company can withdraw immediately. Those would be better questions for Mr. Taylor. But the point here being that if there was a process, the company would expect that consideration of whatever we are obligated to under the Markets Plus governance that we have to do in order to withdraw.
Thank you. And let's assume for the moment that the reason or a reason that the commission were to withdraw public interest determination was because some sort of federal policy that, let's say, prohibited Markets Plus from having a GHG accounting system. So if that were the case, based on what I'm hearing from you, it sounds like after that were to happen, whatever that federal action were, there'd be some amount of time that we have to have a commission process, and then potentially some additional amount of time after that to effectuate the withdrawal. Is that accurate?
Yes, that's my understanding, that there would be some amount of time to effectuate the withdrawal. I'm not sure what that is. And then the company here is saying, you know, in your scenario where there was some change federally that would change the commission's view on whether the company should be participating, the point of my testimony is that we're making a decision here in this proceeding, and that the company should be afforded cost recovery of all of our costs that come with that decision today.
But it would be the case that, you know, if there is some federal policy that is potentially harming or frustrating Colorado state law or policy, it's going to be quite a bit of time, unknown amount of time before you can actually withdraw.
Your Honor, I'm going to object to the premise of the question. Not only is it significantly speculative, but I think anyone who's been paying attention knows that if there were some federal policy that attempted to interfere with the legal process in Colorado or this commission's authority, you can imagine how much litigation there would be over that. So I believe the premise is based upon a faulty set of hypothetical facts. And if she just wants to ask, how long might it take, you know, if the commission made a order to withdraw, regardless of the premise of it, that question might be not objectionable.
Ms. King?
I'm fine moving on. I think we have what we need. Thank you. Mr. Burman, would you agree that we don't have currently any regulations under state law that specifically address the criteria for public service withdrawing from Markets Plus once it's already in?
I'm not familiar with any. I would suspect that the withdrawal process would be part of the agreement the company would sign when we enter the market.
So let me clarify. We have rules, commission rules right now that specify what are the criterion in order to enter a day-ahead market in the first place. We don't have rules regarding criterion for exiting a market. Is that correct, to your understanding?
That is my understanding.
Okay. If the company were to exit from Markets Plus, what types of costs do you think that public service would have to incur associated with that withdrawal?
So I think Mr. Taylor spoke about this earlier from what I heard. Certainly, my understanding is that once a company signs the agreement to enter, those phase 2 costs that Mr. Taylor talked about, the company's percentage of that $150 million, we would be obligated to pay. And then there's the ongoing transaction costs that I assume will continue up until the point where we withdraw. So they're essentially all of the costs that have been put forward here, including those phase 2 entry costs, and then at whatever time it takes to effectuate that withdrawal, the ongoing fees.
And you presumably would be seeking cost recovery for all of those additional costs at that time as well?
Correct. The crux of my testimony here is that we're making a decision with the information we know today. And if the commission approves entry into the market, there are sunk costs the company has to assume when we make that action. So we should be afforded recovery of those costs if there's a decision in the future to exit the market. That would apply to any future costs.
Thank you, Mr. Burman, for the question.
WRA.
WRA will waive our cross-examination of Mr. Burman.
Thank you. Climax.
Ooh, caught me off guard. We will waive as well.
DEC, Ms. King.
Good afternoon. We know each other. I'm Michelle King. I'm here on behalf of the Colorado Energy Consumers.
Good afternoon, Ms. King.
It's your position that the company requires some certainty that its prudently incurred costs will be allowed timely recovery. Is that right?
That's correct.
And by timely recovery, am I correct that you mean something other than base rate recovery?
Generally, yes. And the company's proposed, obviously, ECA recovery here. And yes, given that base rate recovery is typically lagged in Colorado, that's would be referring to something other than base rate.
And so I'm going to refer to this non-base rate recovery as special cost recovery. For this conversation, will you accept that term?
I'll accept the term.
Now, historically, the company has argued that special cost recovery is necessary, particularly where you're required to engage in certain legislatively mandated activities like the Clean Energy Plan, the Transportation Electrification Plan, and that without special cost recovery, you might not otherwise make that required investment. Is that right?
That's fair.
And here you're arguing essentially the opposite, that development and participation in Markets Plus is not a statutory or regulatory requirement, but nonetheless, without approval and certainty of timely cost recovery, it would influence the company's decision ultimately to join the market. Is that right?
I don't know if I'd characterize it as the opposite, but what we're saying is that if the commission's making a determination that it's in the public interest and to the public benefit to join the market, that comes with costs, and those costs should be recoverable.
Okay, Ms. Federico, if we can please pull hearing exhibit 105 and turn to page 6, please. And so, Mr. Burman, I accept that you don't accept the term that it was the opposite, but I just want to point you to your testimony. It's your testimony, and I'll refer you to lines 3 and 4, that that development of and participation in Markets Plus is not a statutory or regulatory requirement. It is not a normal course of business activity. In fact, the entire concept of organized wholesale market participation is not in the normal course of business. Do you see that?
Yeah, and I think the normal course of business is the key there. That's what I typically associate with base rate recovery.
Okay, and so we'll get to that in just a second, but I also want to refer you down to the bottom at line 16 through the end, that approval of the company to join the market without approval and certainty of timely cost recovery introduces significant risk to the company, which would influence the company's decision ultimately to join the market. Do you see that?
I do.
Okay, and so setting aside the characterization that it's the opposite, here, even though there's not a statutory or regulatory requirement, the company is nonetheless seeking what we've termed as special cost recovery, right?
You've termed it as special cost recovery. I think the company is seeking cost recovery of costs that will be incurred as a result of the decision to join the market. And to not allow that cost recovery, but to ask the company to join the market shifts a significant amount of risk to the company about what the recovery of those costs in the future will look like.
So by special cost recovery, recall that we meant non-base rate recovery, right?
Agree that that's what you characterize as special cost recovery as.
Okay, and for purposes of our conversation, you agree to that term, yes?
I did. I don't generally like the term, but I think there's base rate recovery and then there's alternative recovery through riders and other methods. I agree to it for purposes of your discussion. I don't generally like labeling that as special.
Okay, we can use your term, which is alternative. Is that better? That's okay.
Alternative to base rates. I mean, there's
Okay.
many ways to recover costs.
Okay. And so when we talk about alternatives to base rates, right now, the company collects fuel and related expenses through the ECA, right?
That's right.
And that's an alternative cost recovery mechanism. Yes.
It is the cost recovery mechanism for fuel and fuel related costs.
It's a non-base rate cost recovery mechanism.
Correct.
Okay. The company recovers demand side management and beneficial electrification costs through the DSMCA, which is a non-base rate cost recovery mechanism, correct?
That's correct.
And it recovers its renewable energy investments through the RESA, which is a non-base rate cost recovery mechanism, correct?
Correct.
And it recovers its Colorado Energy Plan investments through the SEPA, which is a non-base rate cost recovery mechanism, correct?
Correct.
And it recovers its Clean Energy Plan investments through the CEPR, which is another non-base rate cost recovery mechanism, correct?
Yes, that's right.
And its transportation electrification investments through the TEPA, which is a non-base rate cost recovery mechanism, correct?
That's correct.
And its purchase capacity costs through the PCCA, which is a non-base rate cost recovery mechanism, correct?
That's correct.
And its transmission investments through the TCA, which is a non-base rate cost recovery mechanism, correct?
Some transmission investments, but yes, that's correct.
And certain distribution related investments are eligible to be recovered through the GMAC, which is a non-base rate cost recovery. Is that right?
Presumably will be, that's at issue currently in the DSP, but yes.
And subject to the commission's consideration of the settlement, certain wildfire mitigation activities will be recovered through the wildfire mitigation adjustment. Which is a non-base rate cost recovery mechanism. Is that right?
That's correct.
Now, if we stripped all of these away, what's left of Public Service Company's ordinary business?
The vast majority, I mean, for the most part, all of the things you discussed are far less material than base rates, with the exception maybe being fuel. But the vast majority of the company's infrastructure that it maintains to serve customers is in base rates.
But these costs, which are not fuel costs, would also be recovered through that same fuel mechanism that you referenced, right?
The cost at issue here in this proceeding, they're very much related to fuel costs because they're the cost of engaging in a market where fuel transactions are occurring.
And how material would you say these costs are in terms in the scheme of what's being recovered through the ECA?
They're a small portion of the total of the ECA.
Okay. But yet the potential for delay in their recovery, you say, creates a significant risk for the company. Is that right?
Well, I don't believe that any other parties proposed an alternative way to recover these costs. So it's unclear to me what that would look like, if that's essentially some period of lag with some assurance that they would be eligible for recovery in a base rate case. I think the uncertainty of how those costs would be recovered is what makes the company consider all of the factors in entering the market. So we're entering a market for the benefit of our customers without any certainty around cost recovery.
You're entering a market. Okay, I want to talk about that. So over the years, you and I have had conversations about regulatory lag. Do you recall?
I do.
And you agree that from the ratepayer perspective, the theory or policy rationale is that lag can provide an important incentive for the utility to efficiently manage its costs between rate cases. Is that right?
I agree that that is the theory behind regulatory lag.
Now, from the company's perspective, I can see how regulatory lag may prompt concerns about profitability and creditworthiness. Is that fair?
That's fair.
And this is particularly so when the company is in an investment cycle, such as it is now, with over 22 billion in planned CapEx over the next 5 years. Is that right?
I'm not sure how that relates to these costs that we're speaking of. I mean, we're talking specifically here about mostly O&M costs, which, and especially the front end costs, which are not recurring over more than 5 years of the period which they'd be billed. There's a number of reasons why I would say they don't belong in base rates. You could embed those costs in base rates and then they could end. You're also not capturing them properly annually without, because you're not going to have base rates based on a test year of every year. So there's a number of reasons why, in my view, it wouldn't make sense to recover these in base rates. But specifically, again, the company is proposing to join this market to the overall benefit, right? And I know there's been discussion today about cost benefit analysis, but if the commission determines it's in the public interest for the company to join this market, then they're presumably saying there's benefit to customers for that. Bringing that benefit without consideration of the company's cost to bring those benefits, in my opinion, is where we would have a problem. It'd be inappropriate. And the company would have to consider what that means as far as joining the market if we had uncertainty around those costs for recovery.
Now, I understand in that long answer to my question regarding the $22 billion in CapEx over the next 5 years, if I were to distill that and take a kernel from that you believe the company is doing this for the benefit of its customers and therefore should be entitled to timely cost recovery. Were you present this morning, or I think it was this morning, when I was talking with Mr. Taylor about the potential to add in the billions of new transmission in order to maximize the benefits from SPP Markets Plus participation?
I was tuned in for that discussion, yes.
And do you agree that adding additional billion or more, 1 billion, 2 billion, 10 billion in new transmission provides a benefit to the company in its ability to add that to rate base and earn a return of and on that investment?
Your Honor, I object that there's absolutely no basis other than council speculation for these alleged billions and billions of dollars. So I object to the form of the question, and it also calls for gross speculation.
May I respond? Yes, thank you. I can back up and see whether Mr. Burman was aware of and laid the same foundation for Mr. Burman that I did for Mr. Taylor. I want to be mindful of the time here. I think Mr. Burman, in his capacity as Senior Vice President of Regulatory, is well aware that the transmission applications that the company has filed carry price tags that are in the billions, not the millions in production cost savings at issue here.
Your Honor, though, the witness just said that those are all CapEx costs, and these costs for Markets Plus have nothing to do with that. They're mostly O&M. So I stand on my objection.
Mr. Chair, I think council misunderstands the correlation. The correlation being if the company is making an argument that it should be entitled to timely cost recovery on the basis that it is providing benefits, I think it was on the order of 10 cents 17 years from now, benefits for customers. I think the point is necessary for the record to show that the company stands to benefit greatly from this in the form of the CapEx that comes with SPP Markets Plus.
I mean, I'll let the witness answer it, but it does seem like the link between the new transmission spending and the joint decision to join Markets Plus maybe hasn't been fully established. But Mr. Burman, if you want to answer.
I mean, I guess I was going to say that I wasn't hanging on every word this morning, but it's not clear to me that that transmission investment or any level of transmission investment is tied directly to entering this market. The company has a number of transmission CPCNs in front of the commission that remain the case whether or not we join this market. I didn't think that Mr. Taylor agreed to the premise that joining the market would result in significant transmission investment. And quite frankly, that's out of my realm of knowledge in this proceeding anyway. So I wouldn't be able to make that connection for you, Ms. King.
Okay, thank you. And if the company were to need to invest in transmission to connect with its SPP Markets Plus partners, with other members, that transmission investment would be incremental to the 22 billion of CapEx that's in the pipeline for the next 5 years. Is that right?
Likely, I couldn't say exactly what overlap could occur there, but I'd also just say that any investment in the level you're speaking of would be coming to the commission for approval in the form of a CPCN.
Certainly. Now, the company is seeking that the phase one administrative costs associated with Markets Plus be recovered through the ECA and not in base rates, right?
That's right.
And are you aware that Public Service Company, sister company, Southwestern Public Service Company, recovers the administrative costs associated with its participation in SPP through base rates?
I am not.
Thank you. I have nothing further.
Thank you, Ms. King. UCA, we have 60 minutes, but just seeing what you got.
Thank you, Chairman. Hello, Mr. Burman. Good afternoon.
Do you need the full 60? Should we start?
I'd say definitely not. This will be much shorter.
Okay, thanks.
Hi, Mr. Burman. We've met before, but my name is Patrick Wittershine. I'm representing UCA in this proceeding. It's good to see you.
Nice to see you, Mr. Wittershine.
Thank you for being here. Mr. Burman, do you agree with me that the commission could order the company to recover actual costs through base rates?
The commission could order, the commission could order whatever it sees fit to order.
And the company could still participate in Markets Plus in the event the commission ordered cost recovery through base rates for Markets Plus?
I think my testimony is that that's something the company would have to consider when we saw that order in our final decision to join.
Okay, thank you, Mr. Burman. No more questions from me.
Thank you, staff. I have 30 minutes.
Yes, thank you, Mr. Chair. I don't think this will take more than 15 minutes or so. Most of the other parties have covered. So good to see you again, Mr. Burman.
Good to see you too, Mr. Larson.
So if the commission were to find that the company's participation in Markets Plus is in the public interest in this case, the company does agree in principle with the idea that some form of continued evaluation of the benefits of remaining in Markets Plus would be appropriate. Do I have that right?
You do, that's correct.
And so while the company generally supports continued evaluation of participation in Markets Plus, would it be fair to say that the company's primary concern is just with the specifics of what this future evaluation would look like?
Yeah, I think it's just exactly how that would occur and that it would be prospective and not retrospective to the sunk costs the company would incur based on a decision to join in this proceeding.
Yeah, and to add more color to that, one of the concerns you highlighted in your rebuttal testimony was that staff's answer testimony seems to suggest, those are your words, that future revocation of any public interest finding that the commission might make in this case could retrospectively implicate the company's ability to recover costs, implementation costs associated with this case. Is that right?
That's right.
And I know this is putting you on the spot a little bit. Can you point us to where staff actually suggests in its answer testimony that the commission could go back and retrospectively claw back implementation costs?
I might have had a reference in a couple places in my testimony, but I think that generally it was unclear to me because the staff testimony talked about a number of instances where they proposed guardrails where the commission could provisionally revoke that public interest determination. And in some sections, and I think specific to greenhouse gases and seams, staff proposed a more forward-looking prospective process, but that didn't come through as embedded in, say, the cost cap proposal on the admin fee. So I think the company was just a little unclear and wanted to be transparent in what we would like to see that process look like going forward. So I'm not sure that staff was completely suggesting it, hence some of the language, you brought up there in the prior question. But we wanted to be clear that should always be prospective. And I think the provisional nature of some sort of determination suggests that potentially what happens to cost recovery in that provisional period until a final decision's made.
Okay, well, to try and add some clarity to that, Ms. Federico, can we please pull up staff's answer testimony? It's hearing exhibit 500. And we're going to be looking at page 32. And Mr. Burman, I'm going to direct you to that sentence starting in the middle of line 5 that goes to the end of the paragraph on line 10. And just to set up my next question, I'm just going to read it along with silently with me as I read it aloud. Quote, if the commission finds that joining Markets Plus as proposed by PSCO is in the public interest at this time, it can provide certainty now to the company by approving recovery of Markets Plus implementation costs on a non-revocable basis while retaining the authority to revoke approval for yet to be incurred administrative costs on a going forward basis if future market conditions degrade, end quote. Did I read that correctly?
You did.
So would you agree with me that Mr. Dahlke in this testimony on behalf of the staff clearly distinguishes between implementation costs that could be approved on a non-revocable basis and yet to be incurred administrative costs that could be revoked on a going forward basis after further evaluation?
I would say I read this in the context of the section regarding specifically the greenhouse gas accounting and seams issues. And it was somewhat delineated the sections of each piece here. So that's where I think there was some potential inconsistency in the testimony that on my read. So I don't disagree with what's here being what the company's advocating for. I think the company's just trying to ensure that this applies in all situations.
Thanks, Mr. Burman. No further questions from staff, Mr. Chair.
Thank you. Commissioner Gilman.
I don't have any questions. Thanks.
Commissioner Plant.
I don't have any questions either.
I just have one question. It sounds like the company expects that the total IT cost will be roughly 13 to 15 million. Based on this range, the company estimates IT costs annual revenue requirement of 2 to 3 million. Instead of amortizing the investment and having the company earn a return, any thoughts if we just expense these costs in the ECA as they were actually incurred? Given the overall economics of all this, isn't it possible that a straight pass-through better aligns the utilities incentives and may be more appropriate in this context? So, Mr. Burman?
I think, Commissioner Blank, that's I would have to answer it dependent on how the rest of the cost recovery was ordered. But assuming everything was ordered to be recovered through the ECA, I don't think that that's an unreasonable outcome. And I think that it's likely better alignment than recovering those costs on a lag through base rates. given the short time or short life of those assets.
All right. And then just one last question on process. Any concerns if we ask the company to provide periodic reports, perhaps in a non-litigated process that still allows comments from the stakeholders that would update progress on addressing seams issues and the company's evolving understanding and the costs and benefits of this market?
No, we don't have any concerns with that. I think we have process to provide annual reporting, and if the commission wanted to see something more frequent, we could certainly do that.
That's all I had. Mr. Denman, redirect.
Thank you. So, Mr. Burman, let's turn to the cross-examination by Ms. King. She ran through a list of adjustment clauses the company has in its tariffs, and I'll try to go through these slowly for the court reporter. The ECA, the DSMCA, the RESA, the CIPA, the CEPR, the TEPA, and the TCA. For those, isn't it true that the commission has approved all of those adjustment clauses after the company submitted applications and they were subjected to litigation?
That's correct.
And the other two that she mentioned having to do with wildfire and I have to find my notes. Those are not yet fully determined. The GMAC, those are not yet finally determined by the commission. Is that correct?
That's correct. They are pending in proceedings in front of the commission currently.
And are you familiar with the ECA tariff and its history of various changes made?
Yes, I am.
And can you explain to the commission that the ECA covers more than just fuel costs?
Yes. In fact, the ECA has been used to recover a number of costs in the past, and the tariff has been subject to a number of changes, but certainly it covers a number of fuel-related costs in addition to fuel costs, and maybe the most notable is the admin fees for the Weiss market were recovered through the ECA.
In fact, in the late 1970s, a public service company had an adjustment clause called the Fuel Cost Adjustment, or FCA. Do you know that?
I'll take your word for it. You're going back a little far for me, but
well, my apologies. But the ECA was adopted by the commission after the company's application to replace the fuel cost adjustment, was it not?
I have no reason to doubt that, but would say also that it's common throughout the country for utilities to utilize fuel clauses to recover fuel costs.
And in fact, the ECA stands for Energy Commodity Adjustment, does it not?
That's correct.
Okay.
Objection, for clarity in the record, it's the Electric Commodity Adjustment.
My apologies.
And for further clarity in the record, I'd like to object to the characterization that it was adopted in the 70s, when in fact it was adopted in 2003.
What? I'm sorry. What's your objection?
The ECA was adopted in 2003.
Actually, Your Honor, that's not true. I represented the staff in the ECA case in 1980, so I know for a fact it was adopted in the early 80s. Let's not have
attorneys testifying. Let's let Mr. Burman do the testifying.
I'm happy to do that, Your Honor.
Your Honor, I think the objection then is that counsel is leading the witness on redirect, and Mr. Burman is agreeing without having independent knowledge of the facts that counsel is setting forth for him.
Keep going, Mr.
I'm ready to move on, Your Honor. Thank you. Staff counsel asked you to point to places in Mr. Dalkey's testimony from whence you made conclusions that were in your rebuttal testimony. Do you recall that?
I do.
Would it help the commission understanding why you thought it was unclear to review pages 7 and 8 and the related footnotes of your rebuttal testimony?
Are you asking if we should go to those portions of the testimony?
No, well, no, let me rephrase the question then. In your rebuttal testimony, did you point to places where it was unclear whether Dr. Dalkey was proposing something that was retrospective?
Yeah, that was the comment I made to staff's attorney around, I believe there's a footnote somewhere pointing back to specific areas of Mr. Dalkey's testimony that were concerning.
And would those discussions and footnotes be on pages 7 and 8 of your rebuttal hearing exhibit 105?
Sounds correct. I could confirm it if we look at it.
Okay, thank you, Your Honor. That's all.
All right, I think you're excused, Mr. Burman. Thank you. Any final matters before we reconvene at 1 p.m. Tomorrow afternoon?
I don't have anything on my list, Your Honor.
Does any other party? All right, well, thanks for an expeditious hearing. It looks like we're now on track without any heroic efforts. So see everyone at 1 p.m. tomorrow. Thanks all.
Thank you, Your Honor. Thank you, Commissioners.